Yes.
But I am mentioning for arbitration on the ground of extreme urgency.
What is the urgency?
On the 7th November, 7th September has been fixed as the last term for carrying of the injunction application, whereby my application of order 7 will
Let it be hard. Yes.
8th of September. Kindly.
It's not possible. Entire September dates have been fixed. That is why I have indicated no mentioning for upgradation.
My application will be in work.
Restoration, please hand over the slip.
Application will be infractious then.
Will not be infractious.
Suppose appearing a cycle the state officer has filed an indelibility application without deciding that thereafter
Have to proceed serially. Let me see how far I can proceed.
one thing. But I have filed reply to this report. It's fixed on Monday. If we were try maintenance of the application without being heard, if it is being disposed of.
Nothing will happen.
But I
Nothing.
tell you, the maintenance of the application, what has been done is that maintenance of the application, they have kept it in abeyance, saying that I have already rejected at a previous order, where there was no rejection order given particular.
All right, I will consider. Let me see. Let me proceed serially. Yes.
I have heard on Monday the SC officer.
Nothing will happen. Let me see how far I can proceed. Yes.
Reimposition application. Reimposition application.
Reimposition. Hand over the slip for applications. Execution has been stayed. No urgency. No urgency. Yes, yes. Please.
My lord,
Wait, please.
my lord, may I file?
Lodges kindly.
May I file an application? My lord, server copy is there. Certificate copy was applied, not yet.
When did you apply for the certificate?
Applied on 22nd, 22nd August. Order on 21st August. And give only to file.
Under extreme urgency, I am praying for arbitration. This is an order rejecting to exercise jurisdiction in a section 34. On the ground of that seat and venue. My urgency is that the execution is pending before a coordinate bench. I have taken 3 adjournments from 2024. Matter is listed again on 16th of September. But kindly,
16th of September.
Kindly gives me some precision.
Where it is appearing?
It is appearing at 367 of the month list.
Monthly list.
367. But it's from 2024. We have taken 3 adjournments for the coordinate.
Bandhavada, the difficulty is that I cannot fix it before the vacation because all up to September dates have been fixed.
Kindly fix it immediately after the vacation. We'll request
please come after the vacation. Now it's difficult.
Kindly seize this order. The coordinate bench has recorded the pendency of this civil.
I appreciate that. I'm not disbelieving your submissions. I take your words, but only the difficulty is that up to the end of September dates have been fixed.
But kindly,
even if I accept, please come after the vacation. That is why I've indicated.
We'll have to again seek an adjournment on 16th of September. The bench is very loath to give us any more adjournment. Kindly seize the nature of orders.
When did you file this civil division application?
It was in 2024.
When? Why did you wait, Mr. Bandhavada, for this long time?
We have mentioned. So, in the interact we have mentioned this matter.
Now only
Lordship's bench, we have mentioned.
Now only 16, 17 working days are left, Mr. Bandhavada. Please come after the vacation.
But if your Lordship indicates a date, we can mention that.
Immediately after the vacation, please come. I will consider.
And may I be permitted to mention a contempt application for inclusion in the list?
Please, applications for inclusion, please hand over the slip.
Matter, my lord, pending from 20.
Upgradation.
No, inclusion.
Inclusion under what heading?
Motion. It has not.
Hand over the slip.
Matter, my lord.
Application.
This matter, my lord, has directed the matter to retain its position, but it is not appearing in the list, my lord.
Retain its position, it's not appearing.
In the monthly list, my lord.
In the monthly list, it's
No.
take a note.
My lord, would need to mention a matter under heading upgradation.
Upgradation.
What is called
Please don't mention for upgradation.
My lord, may I be permitted?
My lord, divorce petition filed by wife, and that is expediting.
What do you want?
My lord, the date is fixed from 25/9/25 for the hearing of the miscase on 9/13, and the wife 9/30 days delay.
What do you want?
My early hearing before 25/9.
Yes.
My the date is fixed for hearing miscase before the court below.
My lord,
Maybe. You want upgradation? Please come after the vacation.
Not a single document.
My lord,
Maybe. That,
My lord,
I will consider merits.
My lord, may I be
Extension, please hand over the
May I be permitted to upgradation, my lord?
upgradation.
My lord,
please.
kindly see, my lord, the petition before DRT, my lord, pending for 2.5 years, my lord. There is provision to dispose of petition within 4 months. My lord, the petitioner is an service
There is a
person.
provision if the DRT do not dispose of that.
My lord,
can
kindly-
approach- Sir, please allow
My
me.
lord, petitioner massive heart attack has been suffered, my lord. He is,
Sir, you are not allowing me to make
my lord,
my observations.
my lord.
There is a provision under the Act that if the tribunal do not do that, you can approach the appellate tribunal so that appellate tribunal will direct that. There is a
Direction
provision.
for expeditious disposal, my lord.
That is why I've told you. Since you have said, I've told you the provision. Yes.
1404 matter, my lord, I am suffering a lot, my lord. My lord, I am suffering a lot, my lord, I missed that matter.
Please suffer from 16, 17 working days more. Please come after the vacation.
My lord will kindly then release my matter, my lord, it is very urgent, my lord.
Yes, hand over the slip.
1404.
Hand over the slip. ওটা তুমি মেনশনটা দিয়ে দিন কালকে তুমি মেনশনটা দিয়ে দিন for what then why eviction? What is the order passed? What order you are challenging? If an eviction order has been passed, it's a decree. Appeal lies, not revision. Yes.
Extreme urgent, my lord, the matter, could below, my lord, fixed for the matter 10 September, my lord.
That cannot be urgent.
Unfortunately, my lord, witness, my lord.
Yes.
Item number 1302, my lord. Next day, tomorrow is the next day, my lord.
Maybe.
Kindly, my lord.
That cannot be a ground for urgency.
Actually, mentioning the same thing, my lord, with the formality of having.
Please come after the vacation. Yes, call the list.
May I be permitted to mention a matter? My lord, may I be permitted to mention, my lord?
Management of college, the admission of the students, alert has been stopped. Because the suit was filed naming secretary. Alert the interim order was in the favor of the plaintiff. He has recorded by his name is the first. He was getting public notice with that name. Alert subsequently, rejected. They preferred Bishabi. Bishabi Malad again, they I court Malad revision was allowed and directed the division to the lordship to the correspondence with the college. Lord, I make the application before the university. Lord, I made an application that is pending. Yes, sir. Lord, I have preferred this commissioner challenging the order when an application for additional pardon was filed. It has directed me to select a person to act as secretary.
That is on merit, Mr. Mahato. That is the
It's a running of college, including.
for that writ petition is there.
Petition will not do because the plaintiff has right.
Writ petition is a separate cause of action.
Arising out of the suit.
Why did you then file as writ petition?
Petition for implementation of the civil remedies order.
তুমি মেনশনটা দিয়ে দিন তো দেখে দিই যদি
My lord, may I be permitted to mention a matter? The instant title suit is pending.
what do you want?
For upgradation, my lord. It has been mentioned for 3-4 times, my lord.
Yes,
Kindly
please wait for
consider
some
that.
time. Yes.
Matter for future because the article.
Inclusion under what heading? Please hand over the slip. Inclusion, please hand over the slip.
Custody, alternatively, will not be right of visitation.
All right, yes. Why? Yes, correction. What do you want? Upgradation. Please come after the vacation.
Reason not ask the high function purchaser. Not the entire certificate has been issued.
All right, hand over the slip.
May
Hand over the slip.
I be allowed to mention item number 40?
I will consider, yes.
Item number 401 and 402, which is under fixed matters, and this is those matter DM becomes in functus officio after passing an order. My lord has already heard these matters at length, my lord. My lord, since this matter is pending before your lordship, I cannot proceed before the DRT is not.
Whether DM is become functus officio.
Those matter, my lord has heard this.
Please wait for this week. Yes. Please wait for one.
Another matter for withdrawal, my lord.
Withdrawal, please. Two mention it.
Another matter because for upgradation because there is no such urgency because save and except because the garment trial court is not without accommodation due to the pendency of.
Nothing will happen, yes.
Lordship, new motion for inclusion, Lordship.
Lord, may I just.
One matter for
Lord,
new,
may I be permitted to mention, my lord?
new motion for inclusion, Lordship.
New motion, please, I know. Please don't hand over this. That cannot be a
Sir,
ground
new
of
motion.
urgency. Yes.
Uh,
Yes.
With your lordship, kindly may I be permitted to mention, my lord, item number 431 is the expeditious disclosure, nothing more than that, my lord. Petition is suffering from 2000, my lord.
That cannot be an urgency. Yes.
Your Lordship, 711B, revision pending to be listed in the monthly list of November. However, the opposite party has filed for non-maintenance of, non-maintainability of additional written statement and counterclaim. And,
What do you want?
Your Lordship, listed in this, this monthly list, Your Lordship. That can be, if that can be clubbed together, Your Lordship, that is to be listed in the monthly list of November, but
I'll
711, that revision.
I will consider that when it is taken up. Yes.
Fourth time I'm the agency is the
Please come after the vacation.
rejecting from my.
All right, hand over the slip. Hand over. Yes.
May I have, my lord, kindly, my lord, to mention, lord, extremely urgent matter, my lord. This is
Yes.
in connection with, my lord, a civil divisional application where, my lord, was pleased, my lord, to admit the motion and direct short service. The trial court, my lord, had refused to pass an ex-parte ad interim, against which, my lord, the appeal court had passed an ex-parte ad interim order, and subsequently, however, at the final hearing of the appeal, that order stood vacated. Now, my lord, the construction is coming up, my lord, right in front of my face, my lord, and it is at the fledgling stage. It was
When-
continuing, and my
when-
lord was according.
Vacated, Mr. Banerjee. When it was
My lord,
vacated.
it was vacated, my lord, in sometime, my lord, in April. Then, my lord, on 16th of June, my lord, after, my lord, I had filed, my lord, the civil divisional application, my lord was pleased to fix it for consideration at 2 p.m. My lord, there was, my lord, an accommodation sought on my ground, my lord, and thereafter, my lord, the matter got adjourned. Thereafter, my lord, I mentioned
Please mention after.
that does not have any further dates.
Yes. Please
My lord,
mention.
the construction is going on, my lord.
Nothing will happen if it will be demolished.
My
Entirety will
lord, construction.
entirety
But if
will.
it comes up to a substantial extent, my lord, then that will be, my lord, pleaded against me, my lord. I was enjoying an order, my lord, in the appeal court, my lord, in the lower appellate court.
After the vacation. Yes. Please hand over the slip. Hand over the slip. Yes.
Restoration application has been filed.
Restoration, please hand over the slip.
हमारा ट्रायल कोर्ट
Mention slips are दिए दिन. Yes, please hand over the slip.
My lord, there was we are the defendant in the suit, my lord, and the petitioner over here, my lord. There is one commission to be held on Friday, my lord. If this to be taken, my lord, this is running us in monthly list 435.
Hand over the slip.
Lordship, I am praying for inclusion in the monthly list. The matter was last listed
Under what heading?
CO,
Under what heading? Motion, contested application, what heading?
contested.
Please don't mention now. Yes, call the list.
Madam, my lord, I remember 95 of my lord, please. My lord, fix to be taken off from 3 p.m. my lord. And there is some.
কালকে লিস্টটা দিয়েছেন নাকি? Oh. Yes.
Fix on 3 p.m. Application, my lord. Some urgency. Opposite party saying it is not being there since 2022.
3 p.m. has been fixed when?
Study in the
Please let it be called or let me.
has been declared as a UPM, my lord. The monthly rent is in excess of 10 lakhs per month. They are not paying since 2022.
All right.
Now I am being declared as a UPM.
Let me see how far I can reach. Yes, call the list.
Yeah, that's an answer the petition.
Huh? Oh, it was for correction because contested 12 weeks. This was mentioned.
My lord, item number 5, we appear for the petitioner, my lord.
Yes.
Led by Mr. Sen.
Respondent number 1. I'm led by Mr. Rajeshwar.
Oh, this is that matter. 2 p.m. it has been fixed.
No, that is that matter,
we
are together.
Mr. Shen, with regard to the another matter, do you have your counterpart in the commission? Anyone there? Can you mention before the president in the other matter?
Today,
Today, because that matter is fixed 2 p.m.
2 p.m.
Please try to mention that matter before the president.
for
Drawing-
for taking up our application.
Yes, bringing to the notice of the president.
I would pray, my lord, your lord.
Please do that because that is why.
But then, my lord, I will again
Please come. What is the fate at 2 p.m.? Please ask.
yes,
So we'll ask them to mention today itself.
Yes, yes. Today itself prior to 2 p.m. so that. And also, Mr. Doctor, please inform the other side also.
Yes. Without Mr. Sengupta Allen.
Yes, please inform. Ask any of their counterpart if they can also be remain present there.
My lord, this matter was only kept as to be mentioned. Lordship remembers 227 filed challenging an order, challenging a proceeding under section 14 of the Arbitration and Conciliation Act. I had submitted that the award has, my lord.
Oh, yes, this is for filing of the notes.
No, but there was
Notes, and in case Lordship, we were asked.
Anything to on the any.
I have, because he has cited some judgment. I'll take 5 minutes to distinguish those judgments.
I'll take 5 minutes, my lord. Lordship had put a, my lord, question to inquire whether or to see whether there is a judgment on the proposition that 29A3 consent has to be in writing or it can be implied also.
Yes.
My lord, I have two authorities which I have included in the note, and I will give Mr. Sen also. Kindly first takes my lord. This is, my lord, High Court of Himachal Pradesh.
Have you given a compilation? No.
No, I had, my lord, filed 3 judgments last day.
All right. So you have indicated that no, the new judgment which you will be adding up.
I have indicated that in the note also.
All right. Let us.
My lord, kindly comes to paragraph 22 of this judgment. Paragraph 22. The court can
Yes.
The court can extend the mandate of the arbitral tribunal as per section 29A4. In the instance case, arbitrator entered upon the reference on 8 July 16, permissible period of 12 months within which the award would have been validly pronounced under section 29A1, lapsed on 7 July 17. However, both the contesting parties
Yes. So it can be inferred since both the parties contested without any objection.
objected to the arbitration proceedings conducted. My lord,
Yes, yes. I've seen. So it's the tacit consent on their part for extending the period of arbitration
my lord,
can be inferred.
Kindly takes note of page 101. Takes note of page 101, which is the minutes of 10th of February.
Yes.
Because this is the, my lord, sitting here beyond the, my lord, if I, as my lord, take it that his argument is correct that the mandate expires.
So I think there is no dispute with regard to that. Mr. Shen also did not dispute on that factual position.
Only dispute was whether it is 4th of December or 16th of January. Because so either way, 10th of February, my lord, falls beyond that.
Yes.
Participation was there, hearing, my lord, arguments advanced, hearing concluded, and tribunal asked us to, my lord, file stamp paper for the purpose of publishing award. This is one judgment. My lord, para 22 and 24 of this judgment is relevant.
24 also.
Yes, 22 and 24.
So need not be expressed or in writing.
That's right, my lord.
Language also.
But statute otherwise would have said that this consent has to be in writing. We are trying to read into the, my lord, provision something which is not there. My lord, the other judgment is, my lord, 2024 SCC Online Madras 4338. My lord, kindly comes to paragraph 43. This is Madurai bench of Madras Act. The respondents are very well aware that section 29A1 of the Act provides for an outer limit of 12 months for passing of an award from the date on which the arbitrator had entered upon the reference. They are also aware of the fact that in case if the arbitrator has not passed the award within the said period, the mandate of the arbitrator shall get terminated unless it is extended by consent of the parties or by an order of the court. Having knowledge about the legal mandate, the respondents have not raised any objection with regard to non-passing of the award, waited till an award was passed by the sole arbitrator on 28 March 2018. My lord, the only distinguishing feature here can be they did not wait 7 days prior to that, they filed a section 14 application.
But Mr. Dotto, with regard to this 43, one thing is there, if it is within the time limit, extended, the period which can be extended, yes, there can be a waiver of a right to object. But if the statute creates a bar or puts a limitation, whether that can be waived by the consent of the parties.
So
That's-
if it is beyond the 6-month period, the additional 6-month period, whether that can be waived. My lord, that is a
6 months is, no, there cannot be, but
For-
43, what it has been said here.
My lord, for
Mr.
my purpose in this case, I don't think, my lord, that should trouble your lordship only because of the 10th, my lord, January order of the Honorable Supreme
So
Court.
it's better, Mr.
Which is-
Dotto,
No, this is only because lordship inquired whether there is anything on implied consent. These are the two authorities I found. Maybe, I understand. 1 year period, thereafter 6 months, within that 6 months, arbitrator passing, publishing the award, maybe.
6 months,
waiver-
also there has to be a consent.
Yes.
So there you can say, you can argue that,
That
yes,
implies consent.
yes, it was implied consent since the parties participated without raising any
The
objection.
lordship had put a date, June 2023 or 2024 was the date. Beyond that, it's.
What is 1 year, 6 months, if you have taken at the last cutoff date, then if whether after that consent by consent it can be
That is
extended.
a possible argument which Mr. Sen can, my lord, advance here. Maybe I may not have, my lord, a real answer to that, my lord, argument.
Yes.
But I am protected because of the 10 January order, which specifically carves out exception for proceedings under Arbitration Act, particularly
Yes.
29.
So
if it is.
that's a different thing altogether, Mr. Dotto. You are taking advantage of the suo motu writ petition order,
That's right.
which says that because of those unusual or
That's right.
circumstances, those periods will stand extended.
That's on merit.
That's on merit.
That's on
So
merit. And the other argument I had advanced was, my lord, I had shown paragraph 52 of the award. Any, my lord, finding today by this court would mean that section 34 jurisdiction is being exercised because the tribunal returned the finding in the award itself, how the mandate of the tribunal stood extended by reason of the 10 January order. Paragraph 52, I had drawn my lord's attention.
yes, yes,
Those are my submissions.
yes, Mr. Sen. The Madras judgment, I think you are distinguishing on that line.
Yes.
So we need not take any-
Another important line also, Manoj, is there. Kindly see. This line your lordship will see.
The Madras judgment.
Yes.
Yes.
Paragraph 43.
Yes.
They are also aware of the fact that in case if the arbitrator has not passed the award within the said period,
53.
43 is third line. They are also aware
They are also, yes, yes.
of the fact that in case if the arbitrator has not passed the award within the said period, the mandate of the arbitrator shall get terminated unless it is extended by consent of the parties or by an order of the court.
Yes,
Neither in this case happened.
yes.
Having knowledge about the said legal mandate, the respondents have not raised any objection with regard to non-passing of the award and waited till an award passed by the sole arbitrator on 28th
So,
March
Mr.
20.
Sen, only one thing.
We did-
On to the facts of this case. So in this case, the facts, whether it is this award was passed beyond 1 year and beyond 18 months.
Yes. Beyond 18 months,
So here it has been held, yes, that award is mandate did not terminate.
because the parties have proceeded. And here in my cases, it is completely different.
Last line of paragraph 43 kindly takes note. That implied consent was.
In my case, it cannot be. That is what I am distinguishing. Because the moment once the arbitrator,
But the last sentence of that paragraph,
therefore, it could be concluded that respondents have not only given their implied consent for passing of the award, but also waived their right to object to the passing of the award beyond a period of 12 months.
so anything beyond 12, you waive.
You have waived because you have not taken any objection. But here, I am not saying on the point of,
Challenge to this.
I don't know, my lord, but I am saying on this point, I am not on this point of law also. I am on the factual aspect. Even if your lordship holds that this is a good view, which I am disputing,
Within 6 months.
then also your lordship will see I have not waived my right to object. because I have invoked my right under section 14 before passing of the award. I cannot go to the arbitrator because I have treated him as become functus officio. The only option I had to come to court and say that he has become functus officio. That is what I have did. So therefore, after I have intimated to him.
So your argument, alternative argument is that even if there was a consent of participation beyond 12 months,
Up to 6 months.
Beyond 12 months, up to 6 months, or between 12 to 18.
Yes.
So, but no award could have been passed after 18 months. In view of your invoking of that.
Invoking
so,
of
according to you, there cannot be a waiver of after 18 months.
Absolutely.
Even if waiver can be inferred
from conduct, first of all,
12 to 18 months,
yes,
not beyond that.
Yes,
that's your submission.
That's my submission.
Anything more?
Yes,
it was within 18 months, not after 18 months.
Kindly see once paragraph 34
of
this judgment.
Yes.
Within 18 months.
Since the date of entry has been decided as 3rd November 2016, arbitral award ought to have been passed on or before 2nd November 2017.
This is 12 months.
Yes. Both the parties have submitted their written arguments on such and such. Order was reserved by the arbitrator on the same date. Award was passed only on 28th March 2018.
Within 18 months.
So it is within 18.
November to 6 months if you count, it will go.
They are only.
Now, Mr. Shane, only one thing. Let us take a hypothetical case that beyond 12 months, 18 up to 18 months, let us assume that there was a consent, not tacit. Let us take a hypothetical case, express consent up to 18 months. So till that period, the proceedings can continue. On the last date of that 18th month, the parties have concluded their argument and the judgment was reserved. What will happen to that?
Then once, if a section 29A is already filed, then the mandate remains. Because there is a proviso which says that once the 29A has been filed, even if it is not taken up, arbitral reference can be continued.
No, what is the mandate? What is the meaning of this expression mandate? Whether it is completion of argument or the passing of the award.
Passing of award. Because your lordship will kindly see section 32. Termination of proceedings is in two ways. By passing of an award or by an order of termination. So proceedings will come to an end once award is published. Publication is, so that is why we say
32.
32. Kindly see 32. 32(1). I'll hand over. My learned friend's copy.
I've got 32.
For making and publishing the word, not for.
And your lordship will read this with 29A language. Arbitral proceedings shall be terminated by the
final award. Final arbitral award.
Final arbitral award. And
or by an order of, that is the different
That is a different thing. So until the award is passed.
So award has to be passed within that time.
Yes, and 29A language your lordship will see. Time limit for arbitral award. The award in matter order shall be made by the tribunal within a period of 12 months from the date of
making of the award.
Making of the award. Then your lordship will, that question your lordship will get যেখানে বলছে যে প্রসিডিংটা ফাইল হলেই এই যে your lordship will kindly see the second proviso to subsection 4 provided further that where an application under subsection 5 is pending, mandate of the arbitral tribunal arbitrator shall continue till the disposal of the said application. So if it is today is the last date, once it is filed, 29A is filed.
If not filed, then it gets terminated.
It gets terminated. But I have a right again to file the application even after that 18th month also.
Yes.
After expiry of the
Yes,
period.
but unless and until
I don't do that.
unless and until there's an extension. Unless and until there is an extension by the court.
Extension by the court or pendency of the application. Suppose 29A I have already filed. Court cannot take it up.
Yes.
Even then he can pass the award.
So during the pendency of the application, he can pass.
Yes.
Even if not extended by the court.
Yes. Yes. That is this second proviso. What happens, my lord, that suppose, my lord, the proceedings are continuing, but period comes to an end. Arbitrator.
Here you have filed that application.
Here?
Here you have filed 29A application.
Oh, no one has filed. I have filed 14, saying that you cannot pass the award now. You have become functus officio. Now, the moment he gets this, 7 days the award is published. This is taking advantage of this fact. They could have communicated then and there that the time has not expired. Other side could have said the time has not expired. Or even on the last date, when it was within those 18 months on 17th February when the proceedings last took place. That also there could have been a recording.
What is the difficulty they face? Supreme Court is only protecting those who have difficulties. What difficulty cute basic or anything? That's nobody's case, neither the tribunal's case nor the other.
And your lordship will have to consider the context of the Supreme Court judgment. It is not only paragraph 4.
But Mr. Singh, there is no requirement of filing an application under section 14.
Yes.
No requirement of filing an application under
There is a requirement, my lord. There is a requirement, my lord. You will
file an application. Where is that?
14.2. Because there is a controversy with regard to the termination.
Yes, there is. No, where is the controversy regarding termination?
Because one person, I am asserting my right that you have become functus officio. The other side is saying, the tribunal is saying that we have not become functus officio. Tribunal has not, similar tribunal has no interest in the matter. Tribunal could have said, even immediately upon receiving my 14, that we have become functus officio as per one party. Kindly get an order as to what we should do.
No, 14 you have filed where?
Before the learned Alipur court.
Not before the arbitrator.
Cannot.
Yes, that is what.
Because
the arbitrator was not aware of this fact.
Yes, I have immediately intimated. Serve the application upon the arbitrator.
After filing?
Yes.
And before passing of
And before passing of the award.
7 days before
So there is the point. Once the arbitrator is intimated that you do not have jurisdiction anymore, the arbitrator should have said, let this application be heard out, and even if the award is ready, we will make and publish it subject to the decision of our being functus officio or not. So there was this controversy. And my lord, I would like to just distinguish the 227 maintainability, my lord. Those judgments, with the greatest of respect, my lord, cannot be made applicable because
227 maintainability you have indicated on your notes.
I will, my lord, I will indicate.
You indicate that in your notes.
Just one line are all the judgments, my lord, in the 227, why it is deprecated from orders of tribunal. Tribunal passes an order, say, my lord, 12 or 13 or 16. The statute provides the remedy that if says objection is accepted, then statute says appeal under 37. If jurisdiction is not accepted, then you will have to go through the arbitration, take the point in the 34. Here, my lord, I have not challenged.
So according to you, in cases where there are remedies provided in the statute, so they are 227
deprecated.
But not in a case where there is no express remedy available under the statute.
Yes. On the date when I invoked my right. What my learned friend is saying, that now you can challenge. Now the award has been passed, this same ground you can challenge. But my right has to be seen on the date when I invoked that right.
All right.
On that date, there was no award. So what?
There was no question of section 34 at that point.
At that point of time. And not even that. This is not a point on which my 14 has been rejected. I could have understood the trial court has said 14 is not maintainable. They have not said 14 is not maintainable. 14 has been argued on merits. Now it is to be seen as an order passed by a subordinate court, whether it is amenable to 227. That is only the aspect, my lord, which has to be got.
You have made your notes ready.
Floodgates will not open. Floodgates will open because
Have you made your notes ready?
I have made, my lord, I need my lord, Monday. It will
One
be
day, time more.
I have come prepared with the notes, but I just want to answer your lordship's
No,
question
no, no, it's a judgment.
on section 14.
Well, justice division being judgment, which my learned friend cited.
Of,
Justice Showman Shen, my lord.
yes, yes.
Just one line, my lord. Your lordship will.
Maybe.
What is the cost title, Mr. Shen?
This is
My lord, I gave a
Cole
copy.
construction.
Cole construction. Cole construction.
Cole construction, yes.
My lord, kindly see paragraph 4, the dates. Pleadings were completed on 20th of October 2020. Statement of defense and counterclaim was filed. So this is only completion of pleadings. It is
Yes.
not saying about participation of the parties in the proceeding during the COVID period.
No, this is, no, not the participation.
It is
So
not-
according, yes.
Only filing of the pleadings. By mail it can be filed. Here they appeared.
According to you, if they have appeared, they cannot take advantage of that judge.
They face difficulties in the
Yes. And my lord, that is kindly see, my lord. And my paragraph 6 also.
Yes,
In the arbitration proceeding, this
yes.
judgment of the Supreme Court has been considered and it was recorded that there is enough time for award to be published.
That's the interpretation of
So the parties by consent, despite filing of pleadings, wanted to take recourse to Supreme Court judgment and extend the time. Here in our case, I have been
Mr. Shen, applicability of the Supreme Court judgment, does it require the party's consent?
yes, but because it is for my benefit. It is not something that it is not a pure question of law. The law has been suitably enlarged. The time prescribed has been suitably enlarged, keeping in mind that you will be put to inconvenience so that you do not suffer a legal disability. But both of us have waived that right. Therefore, I cannot, at the fag end, I cannot come and say, no, the time is still running. If I had taken the benefit and still I wanted to rely upon it for the benefit of the parties or the tribunal, it would have been expressly recorded. Only after I have invoked my right, you are now trying to, the arbitral tribunal is now trying to say in paragraph 52.
So according to you, by the award, your right was frustrated by passing the award.
It's a jurisdictional error.
Yes.
They became functus officio. This is my submission.
Kindly take section 14 once, just to answer my lord's question. Yes, and I am filing my notes also. Mr. Sen says he will file it on Monday.
Already served.
Well, let him rush to the other court, whether the other matter is being
And
called.
Mr. Sen is leading me, so I am a bit relaxed.
Well, I'll take your lordship's leave.
Yes.
Well,
yes.
kindly take 14. I'll just take
When shall you
Can
file?
we file it on Monday? Just mention and file the notes, my lord.
All right, I will direct this matter to appear under the heading to be mentioned on Monday.
now the file করবো? But we will file it today.
All right, keep it with you. I will record that. Yes,
My lord, section 14.
yes.
First, subsection 1. Mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if he becomes, my lord, de jure unable to perform his function. De jure would be, my lord, he lost his mandate. So, my lord, it is an automatic termination of mandate if, my lord, 1 year plus 6 months expires and the arbitrator feels. How would the arbitrator know? My lord, one of the parties would communicate to the arbitrator that this is the situation. Maybe you are no longer having jurisdiction or the mandate to continue. This was not done. On the contrary, my lord, they approached the, my lord, court, the Alipur court, 7 days before, my lord, the publication of the award. My lord, the opportunity to file an application is only there in subsection 2 of section 14, which kicks in only when there is a controversy. Now, my lord, this controversy can only arise when, my lord, one of the parties is asserting that yes, you have the mandate, the other is saying no, you don't. And the arbitrator. And the arbitrator decides on the controversy. Once that controversy is decided either way, my lord, the right to, my lord, or the controversy remains,
All right.
the right to apply, my
I
lord.
follow your argument. Have you indicated that in your notes, this point?
My lord, I will file the notes on Monday itself. my lord.
File it on Monday then. Indicate this point.
Yes, my
Uh, Heard,
The petitioner, my lord. Yes, I'm for the plaintiff petitioner, my lord. My lord, this is suit for, my lord, declaration and injunction, my lord.
oh, there's a correction. Huh? It has been pointed out that there is a type of
Yes. My lord, the suit is for declaration and injunction, my lord. I'm for the plaintiff, my lord. My specific case, my lord, that by inheritance,
My lord, in item number 8, my lord, I'm praying for a short passover, my lord, on behalf of Mr. Saurajit Dasgupta, my lord.
who is appearing?
My lord, Mr. Saurajit Dasgupta is leading me in this matter, my lord.
Yes, what is
Wait
this,
for-
Mr.
My lord,
Have you
we have
got
prepared, we have
calculated?
forwarded the But we have calculations. Our calculations,
Calculation has been exchanged.
my lord.
Yes, so.
So,
what
but the
is any
admitted amounts, according to us,
dispute with regard to the calculation?
a huge dispute. my
There's a
lord.
dispute,
Yes,
huge dispute.
huge dispute.
Please give your calculations, both of you.
Just-
Yes, Mr. Rai, what is your admitted amount
71,000 and odd,
and what is their
2
claim?
lakhs and odd subject to
2 lakhs and
2,82,000, my lord. 2,82,000.
2,82,000.
So,
Mr. Rai, you put in the 71. 71 is the admitted amount.
yes, yes, yes. Wait.
71.
Now, my lord, the one question you cropped up, how the opposite party can, the petitioner can, opposite party can encash the D1 draft.
Why?
But in his statement of accounts, she said she does not have any bank account. That's why she did not file the banking
We have
statement.
provided a bank account, my lord.
You have a bank account.
We have
Then-
provided in our calculation sheet, my lord. The last page of it, my lord.
Last page of
Last page, my lord, in our council calculation sheet, my lord, the last page of it.
Yes, yes, yes.
Yes, bank account nahi boli
oh, in your calculation sheet.
my lord.
But your learned friend is saying in the
Yes,
affidavit of
74.
affairs you have suppressed your bank account.
74, I do not know whether, my lord, they can, can encash this draft or not.
But 70, my lord.
Yes, yes, please verify the
15.
name of the
74, 15. Page 74 I have annexed.
'74.
My lord, furnish copies of bank statement of all accounts
Not
for the
applicable.
You have
last
said
3 years.
not applicable.
My lord,
You have said not
my lord,
applicable.
subject to correction, my lord, these are bank statements.
Yes. Why not applicable?
My lord, there has been
Then you have suppressed.
my lord, she has a joint account with her mother, my lord, which I believe
Who is the first account holder?
my lord, the mother of the opposite party, number 2, my lord.
Do you have the account?
I have to take instructions on this part, my lord.
What instructions on
My
that?
lord, on this part of bank account, my lord.
Bank
But as
account.
far as, my lord, the calculations are concerned, my lord, there is a dispute of regarding.
Calculation, he is admitting 71,000. Take 71,000 for the present, have something before the puja vacation.
But my lord, may I just point out one thing, my lord? My learned senior has submitted that he had been paying 4,000 all this while.
Please take the admitted amount. I am not disposing of it of now. Mr. Rai, have you brought the bank draft? Bank draft or check, whatever.
Bank draft.
Bank draft.
That is why I have an impression whether it can be at all ordered or not.
Sir, please check the spelling.
And whether it can be ordered or not. Does not have any bank account, how this bank draft will be encashed.
Have you checked up the name? It's correct.
I'm seeing it, my lord. I'm seeing it right now. Check one. ये तो एखान থেকে match করবে।
Pursuant to the
Order number 9.
Lordship, I am from the.
Yes,
Lordship, this is my affidavit of service, Lordship. The wife is the petitioner before your
where is
Lordship.
the husband?
Lordship, I have served, he has received, but no one is appearing.
No one is appearing. Ms. Chakravarti, can you give me 2 more days?
6th is the next date.
6th.
Lordship, these are, Lordship, bunch of some of the cases where, Lordship, the
6th is so this Saturday is the next date. For what?
Lordship, for evidence, for hearing of the main application, 13B. So without my evidence, Lordship, how can, Lordship, hearing be done?
No, what
Lordship,
is
these are
that?
bunches of some of the orders, Lordship, passed by the.
But there are
Subject
some
judge.
difficulties because I tell you, because I tried to inquire. First is that there is no notification with
Yes,
regard
yes.
to that. That's I've checked up.
Yes.
Now, secondly, is that a central rules have come in. So now this rule has by this time lost its force. Now the central rules with the new 2 acts that has been incorporated. That's the second thing.
Just a
Second,
present.
no, the infrastructure is there. Infrastructure wise, there is no problem. Infrastructure is there. Even if it's not functional in the particular court, a video conference room also can be arranged. There's no difficulty with regard to that. But there are some disputes with regard to the remote point. So that's the real difficulty. So unless there is something in the rules, so you have to appear before a remote point. So unless that is being allowed by the rules, there will be a difficulty. Your evidence, you may, because the order which I have seen is perfectly justified. This order does not suffer from any infirmity. So please give me 2 days. Please pray for an adjournment. Please take a short date. I'm keeping in the next week, Tuesday or Wednesday, because this has something. Otherwise, the order is perfectly justified.
But
So in order to
Lordship, I have handed over a bunch of the orders passed by the learned trial court at Alipur, Lordship, by the district judge at Alipur, where Lordship parties are residing in different countries. Lordship kindly takes up page 2, Lordship. This is in respect of a matter, Lordship, where petitioner number 2 was staying at Thailand, Lordship. So, Lordship, through Advocate Commissioner, it was done.
through advocate commissioner appointed there.
No, appointed from here. From here.
The difficulty is that who will identify in
Lordship,
their remote point. There are some.
also be present.
Please come on Tuesday. Please come on Tuesday. Please pray for a short accommodation. The affidavit of service filed in court today is taken on
File has been placed, my lord, that is of 2024, my lord. this matter will appear in the list tomorrow, my lord.
What for? This is correction it appeared.
My lord, but my matter was in the list, my lord, appearing in the list. That is my matter, my lord.
To mistake the number instead of 2024, it was mentioned 2025. That is why your matter came.
My lord, it was in the list yesterday, my lord, and today, my lord.
কালকেও ভুল করেছিল। No, this was direct. This is appearing under the heading to be mentioned. Why your matter will appear under the heading to be mentioned?
Not under the to be mentioned, my lord. This is new motion matter, my lord. And the yesterday matter first time was appearing in the list, my lord. And today is also appearing in the list, my lord.
Oh. Tomorrow in the
Tomorrow, written exposition, my lord. Other
It will written exposition.
Grateful.
Yes. Call the next matter.
The interim order was passed on 17th of September 2024. Thereafter, it was mentioned for a number of times could not be.
December
Taken out, my lord.
December.
The change of determination was there. And by the passage of time, there was no court in the trial. That's the reason why it was not moved.
December 2024 interim order, I am not on that. His suit for eviction.
File an application for
I'm giving consent. Suit for eviction.
Consent for allowing this application.
If you are kindly hear me 1 minute. But suit for eviction, DW.
Who are you?
I am the plaintiff in a suit for eviction. Now, my lord, it is in the evidence stage. My evidence was closed. Now, my lord, he appeared, then he prayed for time that he will issue summons for bringing the evidence, bringing the witness. Now, my lord, he did not put the requisite for issuing summons. Court give a last chance. He chose not to bring the witness. Then next day he prayed for time that the summons has not been served or there was no direction. Now, court recorded and found that he has deliberately did not bring the witness. Court has closed the witness. Now, my lord, kindly fix the date. Let him produce, and this should be decided within certain time.
His consent.
Yes, sir.
No, no extension.
Extension. He wants your revision application to be allowed.
Yes.
Revision application if allowed, my lord, the judge is moving very fast.
To move fast. You cannot delay that.
See the intention.
What he has
That
done,
cannot be a ground.
Your lordship, what he has done. But when the petition was filed
Sir,
before you,
It was what is the impugned order?
impugned order, my lord, summons issued, did not receive by the witness, so he cannot come to the court. Evidence closed, argument fixed.
All right. So we put in the requisites on the.
Can you fix the date? When the witness will witness, he will bring the witness. Kindly fix the date and
My lord, I can bring it only, my lord,
tomorrow is the date, my lord.
after the next week. is
Tomorrow,
over.
Mr. Mukherjee cannot be
Very
done.
well.
So I'm directing the learned trial judge to fix a date for that.
Bringing witness and should be disposed of within certain time, my lord.
I don't mind, my lord.
She's to have
Yes, sir.
consenting
And,
to
my
you.
lord, what is the suit for? My lord, both the beneficiaries under the.
I'm not on merits.
Mother suing.
His suit may be dismissed. Get his suit dismissed.
But,
You have a very good case on merit.
my junior, may I leave, my lord? But may I leave, my lord?
Why?
One matter has been called. তাড়াতাড়ি নিষ্পত্তি কথা বলে।
This application under Article 227 Matter number 11. Yes. Yes.
I have a very short issue involved with this application, my lord. A dispute over a piece of land. The plaintiff filed an application petition under for permanent injunction declaratory suit in 2019 on the same cause. Thereafter, petitioner gifted the property to his wife and daughter. Thereafter, another suit, my lord, is filed by the 2025. Another suit has been filed by the respondent in the opposite party in the earlier suit. So, well, in view of section 52, so this second suit is not maintainable because any result, section 52 of TB Act, my lord. This is 58. Paragraph 18, kindly see it. Paragraph 18. Because any result that para 18.
Yes. Paragraph 18, where it has been said that the suit will not be maintainable.
No, my lord, on the same property.
Yes.
First suit is 2019.
Yes.
And in the during the period, the dependency suit was gifted to his daughter and wife.
Yes.
Thereafter, on the same property, the respondent filed another suit.
Section 52 is transfer pending related.
Yes, my lord. This
Yes.
is during the.
So why the suit will not be maintainable? Subsequent suit
on the
it
same
has not
property.
been said. Subsequent suit will not be maintainable. Where it has been said. It's the other way around. It says it's not to render transfers effected during the pendency of a suit by a party to the suit void, but only to render such transfers subservient to the rights of the party. It's the other way around. So it does not say.
I was the plaintiff in the earlier suit.
Maybe that does not. Section 52 does not say that the you do not have a right to proceed with the earlier suit.
No.
This judgment also do not say that. Yes, what is the impugned order? Please show me the impugned order.
Amendment order.
Yes.
On the same second suit, on the same property.
Yes, amendment allowed.
Allowed.
Amendment, where is the plaint?
Plaint by which is not. Page 22 original plaint, my lord. This is 2009.
This is the present suit.
This is the original suit. Earlier suit.
Please, the plaint of this suit. Please show me that.
এই পরে সুটটা কোথায়?
ওরা যেটা ফাইল করেছে।
ফাইল করা
Where is the plaint? Where is the amendment application?
This is by a suit. 7 কোথায় আছে না? এটা কোথায়? কোনটা কোথায়? এটা
Yes, and where is the application under order 6/17 for amendment?
Application to the Order application amendment.
What is the amendment sought for?
You can please change the word.
যেটা separation of fact করেছে সেটাই
Oh, actually they suppress the fact that the
One has been recorded, there was some typographical errors which were sought to be amended. It's a formal amendment, Mr. Chairman. Ashun, this application under Article 220. Yes, call the next matter.
Number 12. Suit for declaration of right title interest and injunction.
Yes.
The petitioner is the defendant number 3 and 4. My lord, suit decreed. Subsequently, my lord, title appeal filed.
Suit decreed. Title appeal
Filed by the petitioners, defendant number 3 and 4. My lord, during pendency of the appeal, my lord, respondent number 1 and 2 has died.
They are the plaintiffs.
One was plaintiff, one was defendant number one. My lord, substitution application was filed, my lord. So far the plaintiff is concerned, substitution was filed in time. But so far the defendant number one is concerned, it was, my lord, delayed 330 days, 337 days. That application has been rejected.
So there were two applications.
Two applications.
Yes.
One application has been allowed.
So far two miscellaneous cases.
Two miscellaneous cases.
One miscellaneous case has been allowed.
Allowed.
That was within time.
Yes.
And
the defendant number one is concerned, that has been rejected, my lord, that ignorance of law is no ground.
Rightly. Where is the wrong? Is it a ground? Ignorance of law?
No, my lord knows, my lord, the milksman.
Sexual expression shows Mr.
My lord
Mahato.
knows, my lord, milksman case. Milksman case, my lord knows. My lord, we are relying on that, my lord. The application is at page, my lord, I have stated the same fact, my lord. It is paragraph 3, page 16.
But order 22, rule 9.
My lord, setting aside abatement upon condemnation of delay.
Yes, if it is rejected. If it is rejected, it's not a
title appeal. Title appeal. In title appeal. In title appeal.
Yes,
therefore revision.
In title appeal also,
title appeal, my lord, revision, I have checked out.
because by virtue of it's not akin to order 39 rule 1 and 2. There's a distinction. Here, in substitution, order 22 also applies in case of appeals. So if that applies, so whether under order 43 it will be an appeal. It's not like akin to order 39. Mr. Mahato, you are right. In order 39 rule 1 and 2, if in a title appeal injunction is rejected or either way, no miscellaneous appeal. But because order 39 rule 1 and 2 says in a suit, not in an appeal, there lies the distinction. Order 22 says provisions of this will also apply in appeals. So there's a distinction between an rejection or allowing an order 39 rule 1 and 2 in an appeal and order 22 rule 9 in an appeal. Have you considered this?
But I have
From where are you saying no? It is revision is mental level. Where from? Do you have an authority on this?
Today I have not brought it, but before filing this revision, I think over this matter. I think over this matter
Yes.
whether I shall file appeal or revision.
What is your reply to this? What is your reply to this?
So far
It says an appeal, order 43 rule 1 says, an appeal shall lie from the following orders under the provisions of section 10.
Yes, that is there. That I have seen.
Yes. So now, order
Rejection of
22
amendment.
rule 9 refusing to set aside.
Yes. That is appealable. But since it is in appeal, therefore a revision is required. If it is in the suit, my lord, I have to file the appeal.
But the only thing, Mr. Mahato, is if it is order 22 is not in a suit only.
No.
So it also applies in an
In
appeal,
appeal.
unlike order 39.
Yes.
There's a distinction. So, yes, Mr. Ghosh, what do you say?
Section 104 and brought their earlier decision in 1963 CW by Vijay Mukherjee. Subsequently brought the Honorable Justice Homen Mukherjee and Honorable Justice B.C. Rai. They held that appeal will lie. Subsequently brought a single bench held that is per incurium in view of the earlier decision and in view of section 104. No second appeal lies. Thereafter the another single judge held in 1994 Calcutta held no appeal lies in view of division bench. Ultimately, the matter went to the Honorable Justice Rumapal. As your Lordship then was, Lord, the matter was ultimately referred to a larger. The Honorable Justice Ganguly, Ashok Kumar Ganguly, Honorable Justice S.P. Talula, they held that no appeal will lie, division will lie.
Where is that?
Lord Basil Jared versus Jagabandhu Mondal. I name all these things. This is the position. No second appeal, but revision. and injunction.
Yes, please consider that.
Take here.
104,
100.
Mr. Ghosh, there is a distinction. 104 does not say suit or anything. It says an appeal shall lie from the following orders, 7 except provided in the court, and from no other orders. So, and order, there is a distinction between order 39 rule 1 and 2 and order 22. Order 39 rule 1 and 2, it says in a suit, but order 22, it's those provisions will apply. If that is applied, then order 43, that order is also an appellable order. Because these are the distinction. Injunction, that's the language, that's the full bench also. It says since it is in a suit, not in an appeal, yes, revision will be maintainable, not an appeal.
Yes.
But order 22, by its implication, it says that it will be applied in appeal also.
Order 22 has been rejected.
Yes, yes. No.
Order 22 will be
22,
rejected.
Mr. Ghosh, order 20.
Ballot provisions of order 22 will be applicable in appeal.
Yes.
Means, my lord, I am to file the application for substitution, setting aside abatement, all this.
Yes. So if.
But my lord, the provision of order 43 will be
Order
applicable.
22 rule 11. In the application of this order to appeals.
Yes.
So far as maybe the word plaintiff, these are have implications, shall be held to include an appellant. So that will be substituted. The word defendant, a respondent, and the word suit, an appeal. So it will be bodily lifted there. In all the provisions of order 22, also in 9, it will be bodily lifted, the expression suit with the appeal. So if that is so, in order 43 also, that expression order 22 rule 9 has to be in an appeal, an appellable order.
In that event, my lord,
Because this is to be only not, you will have to substitute. It says suit will be replaced by the word appeal, plaintiff by the appellant, that by the respondent.
You mean that is what it is a miscellaneous case. Abatement was sought to be set aside.
Order 22 rule 9 rejected.
This is which case?
In the miscellaneous case.
In the miscellaneous case, all the provisions of suit will apply under section 141 of the Civil Procedure Code. Your lordship, can you see?
No, that is the procedural aspect.
Procedural aspect.
But
I'm not telling.
Procedural aspects that will apply.
Yes.
There is no dispute with regard to that. But it's not it's a title appeal. Title appeal death occurred, for which order 22 rule 9 is registered as a miscellaneous case.
Yes.
So now whether that order is an appellable order or not an appellable order. If it comes within order 43, order 22 rule 9, it's an appellable order. Then order 43, it may be an appellable order.
well, kindly take it out tomorrow. I shall.
Question should be, my lord, let us consider the matter. My lord may be right.
Because that is the distinction. Order 39 rule 1 and 2.
Yes.
Here it's being bodily lifted. All suits with appeals.
Well, I shall come back tomorrow, my lord. With you.
This, sir, I am keeping the point of maintainability open.
Yes.
By the order impugned, Mahato, please consider that.
Because I shall be in difficulty if it is be available. Now it is within time. And subsequently it may be again condemnation of delay, all this. Therefore, I shall think over.
Mr. Mahato, apply what was being done earlier in this type of cases. Please, judge. Please advise your client accordingly. Nowadays, that practice has been stopped. Yes.
That the plaintiff, that respondent in the title appeal is the petitioner before your lordship.
Respondent in the title appeal.
For eviction, initiated on the
Occupation
ground of-
charges.
Occupation charges. Initiated on the ground of default as well as reasonable requirement.
Yes, what is the amount of occupation charges?
They are occupying the entire building. There are 2 floors in the ground floor, 2 floors at the first floor.
What is the occupation charges?
10,000 at the Jora Bagan. It's 500 meters from the metro station.
Dilapidated building, Mr.
That is also not, Milord. Kindly consider. It's not 10,000. Milord, I know it should not
The
be
application disposed of. What is the stage of the appeal? You are not interested in the eviction.
Yes, Milord. I got the decree for eviction.
I'm expediting the appeal.
Milord, a person who is, Milord, enjoying the entirety of the building at Jora Bagan. It's 500.
And where are you residing?
I'm residing elsewhere.
You have an alternative accommodation.
Both ground, Milord, should decree. 7-2 not complied with.
On that ground.
No. Also reasonable requirement. 7-2 not complied with.
Then where is the 7-2 not complied with defense strikeout? So you have got a walkover, Mr. Mukherjee. You have got a walkover.
No, Milord. Yes, 7-2 initial compliance is there. Thereafter 7-1C, the court ultimately.
So 7-3 defense was struck off.
No. At the time of final hearing of the suit, the court found from the record that 7-1C subsequent non-compliance is not there. That's why he has got fullest opportunity to not participate before the trial.
That was not considered.
That was not considered prior to that. That's why defense was not struck out. So he has got opportunity.
No, defense was there, evidence was also there.
Everything.
But at the time of passing of the final judgment, I think those were not taken into consideration. The cross-examination part, what has come out from the cost.
Everything was done. The issue with regard to the default has been decided in favor of me since 7-1C subsequent non-compliance of the deposit of rent is being considered by the learned trial judge. But at the time, Milord, I have annexed the judgment. At the time of...
You have a very good case on merit.
I have. But
I'm directing the appeal.
Milord is occupying, Milord, the entirety of my building.
What is your claim with regard to the occupation charges?
Milord, my claim, Milord, I have stated, Milord, the valuation slip is also being annexed. But Milord, the learned judge is of the opinion, he considered, Milord, all the judgments and he found 10,000 may be given. Milord, at Jora Bagan, your lordship, if apply a Robert's consents, then also. Milord, this is something, a person is occupying entirety of the building at Jora Bagan. Can it be, say, at 10,000 per month? 30 to 35, Milord, at least the rate of rent.
By the order, the petitioner next. You are there, coming after 5 minutes.
One indulgence, my lord. Yesterday, leave was granted, and the whole day was gone for affirmation. My lord, today they are saying the date should be changed, my lord. That leave to be granted. I'm grateful.
Yes.
Appear for the petitioner, my lord.
Yes.
Appear for the caveator petitioner. A petitioner is a plaintiff in the court below. A suit for eviction filed in 2000.
You are appealing for the opposite party. Yes.
Suit for eviction filed in the year 2015. Ex-parte decree was on 8th June 2022.
Order 9, Rule 13 allowed.
Yes. Okay, kindly cease, my lord. The original tenant died in 15. He was not there. He was residing somewhere in Jharkhand. I made a paper publication to explain to the defendant number 3, whom my learned friend is appearing. Obtained a decree, my lord. The paper publication was accepted by the court. Widely circulated newspaper. That was not considered. Now, I am suffering, my lord. The suit property at Barashat, one shop room over the colony more. I am not receiving anything, 220 rupees rent.
Yes, Mr. Bhattacharyji,
The
but
finding
the
comes to page
my
60.
finding is that the person was residing in Jharkhand at the point of time and the paper publication was made in Bengali.
Now, kindly see
So
page
we
68.
do not have any wide circulation.
Kindly see 68, my lord, page 68.
Yes.
That was accepted by the court. Jharkhand, Bottoman newspaper, Jharkhand, Bengali is the second most popular.
What is the newspaper? Which
Bottoman.
It has wide circulation in
Yes. Jharkhand is very popular. Second most Bengali is second most popular language, my lord. The 7172 filed by defendant number 1 that has been rejected, my lord. Now defendant number 2 ex-parte did not contest. 4 ex-parte, 3 summons was served.
No, my lord, it was
Thereafter newspaper publication was made. He was also not reside with the original tenant that time. Original tenant died in 2015.
Anything more? This application under Article
Item number 50, my lord, I'm appearing on behalf of the Cholamandalam Investment Finance Company Limited, my lord. My lord, the learned counsel appearing in this matter, my lord, Mr. Ranjit Singh is outside station, my lord. He is not appearing.
What is the order which you have challenged?
My lord, list this matter after puja vacation, my lord.
On the prayer of the learned advocate for the petition, list this matter in the month of September 2025. Yes, next.
Item number 16.
Yes.
I'm for the caveator opposite party.
Yes, Mr. Rai.
I have sought, my lord, this is the executive part.
Yes, he is appearing. Yes, what is the order? You
Application under order rate rule 9 for leave to file additional WS that was rejected. And against that, we are before your lordship. My lord,
what is the suit for?
Suit for declaration and recovery of possession from a licensee as per the plaintiff. My lord, kindly come to the written statement. In the written statement, nothing is stated. What is the defense? And that is why lordship kindly come to page 21.
You have chosen not to state anything.
My lord, that is the erstwhile learned advocate has done, and we have stated in order rate rule 9
At what stage you have filed this application?
Yes. Stage already PW1 has started. PW1 has started, but it is a case that
PW1 has started, meaning thereby
Further cross-examination.
further cross-examination. Yes.
stage is very late stage. That I do admit. My lord, subject to payment of cost. At least I can take my defense, because when I will lead the evidence, the problem will be elsewhere. Nothing is in
counterclaim.
Yes, along with counterclaim.
Along with counterclaim. Even if
along with counterclaim cannot be done. 2020 volume 2 SCC.
There is some.
There's a 3 judgment.
Yes. Lordship, it is marked.
So usually the cutoff date is to be framing of issues, exceptional cases till the starting of the evidence. So even if it is accepted to be an exceptional cases,
but
nothing beyond counterclaim cannot be allowed.
Leave the counterclaim. Kindly allow me to take the defense.
At the combined application. This is a combined application. If you are entitled to take your other written statement, you can.
Liberty may be granted. Liberty may be granted. Kindly give me liberty. I will.
This is
for counterclaim, since my specific case that I am a tenant, co-tenant.
Nothing prevents you from filing a fresh suit. You can file a fresh suit. What prevents you from filing that?
Let me waive the counterclaim, exclude the counterclaim, and file an appropriate application. Kindly make it clear. This divisional application may be disposed of on that findings. Other facts will remain.
It's for the purpose of only incorporating the counterclaim. Nothing.
No. Kindly.
Comes to page 29, Lordship.
If not para 3.
No. Abatements. No. Abatements.
Abatements. Kindly see that my
additional written
father-in-law
counterclaim.
My father additional written statement may be accepted. Forget about the counterclaim. My father-in-law was the tenant, and I have inherited.
Where is your original written statement?
Page 21.
Page 21. Nothing has
Where is
been
the
stated.
plaint? Show me the plaint.
Page 15. Page 12. And in para 4.
Just give me a minute.
Kindly come to para 4 and 5.
Yes, where is the written statement?
Written statement.
Original written statement.
21.
My lord, in the before that, lordship kindly come to para 4 of the plaint. It may be mentioned here that said Ashok Kumar Ghosh, since deceased was the brother-in-law of the plaintiff, being the cousin brother of plaintiff's husband, Sri Asit Ghosh. After purchase, sir, one of the co-tenant has purchased the property. One of the co-tenant, and I am saying that Asit Ghosh, Ashok Kumar Ghosh was the co-tenant. So that cannot be taken away. In written statement, nothing has been stated.
Lordship, paragraph 12 of the written statement at page 12. He's saying that he's a co-sharer of the suit property.
Co-sharer means co-tenant.
No.
Co-sharer.
Of course not.
Purchase is totally, the defendant says that the original owner of the suit property was by way of was a bona fide co-sharer. Yes, it was a bona fide co-sharer. That is your case.
That is the co-sharer
Side,
means
as co-owners, co-sharers.
owner co-sharer, my lord. That is a
That's
co-sharer
your
means
written statement case.
Original
Now what
written
you are
statement.
trying to state?
That he is
kindly come to
tenant.
no. Kindly come to
Page 29, Lordship.
additional written statement, page 29. Defendant states para 2. Originally, as it appears that one Rajendra Mollik, since deceased, was the owner of the suit building, who granted lease of the same in favor of Subodh Pal. One Charuchandra Ghosh, the predecessor in interest of the parties in the suit, who acquired tenancy of the suit building in the name of his two sons, namely Shambhu Charan Ghosh and Santosh Kumar Ghosh. I am coming under Santosh Ghosh from the said Subodh Chandra Pal, and thus the predecessor in interest of the parties in the suit were inducted by the said Subodh Pal as tenant in respect of the suit building, subject to payment of rent occupation charge at the rate of ₹35 payable as per English calendar month. Be it mentioned, be it noted that Shambhu Charan Ghosh and late Santosh Kumar Ghosh were two full-blood brothers, and the entire family of the above named two brothers had been occupying the suit building and paying the rent occupation charge for the same. He said Santosh Kumar Ghosh, son of late Charuchandra Ghosh, the predecessor in interest of the parties in the instant suit, died in 1992, and then para 2, thereafter on the death of Shambhu Charan Ghosh and Santosh Kumar Ghosh, their respective sons, namely Asit Ghosh, my husband, son of late Shambhu Charan Ghosh and Ashok Kumar Ghosh, since this is son of late Santosh Kumar Ghosh, took management of the suit building, and family of both the brothers were in joint use and occupation of the suit building. It was agreed and understood between the said two brothers, namely Asit Ghosh and Ashok Kumar Ghosh, since this is that both of them would jointly purchase the suit building, being premises number so and so. It appears that suppressing.
So your case is that these Ashit and Ashok, they decided that they will purchase it jointly.
Yes.
But only Ashit purchased.
Ashit purchased and Ashok,
in the name of his wife.
And Ashok.
So and you are residing there.
And Ashok was one of the tenant. Ashok was one of the tenant which he inherited, my husband. Sir, that is stated in subpara 2.
Yes.
Sir,
so now
I want to incorporate this only. Forget about my counterclaim. I am giving up my counterclaim. Kindly allow me to add this. Kindly delete para 3. I can file separate application to that effect. That I don't want a counterclaim. If I can establish by cross-examination that it is a case of joint tenancy, the suit will fail. The suit will fail. And at this stage, if I file any separate suit, then section 10 of the Civil Procedure Code will come into operation. Their suit is the earlier suit, previous suit.
Yes, where is your application for leave?
Kindly come to page 26. Sir, I have said para 3. I have not suppressed. Very recently, the defendant, before proceeding with the further cross-examination of the PW1, has consulted with one learned senior advocate who, on perusal of the original written statement, has noticed that relevant facts touching the defense of the defendant have not at all been stated in the written statement, 7 except some denial of the alleged statement made by the plaintiff in the plaint. The para 4, the defendant further states that she has been accordingly advised to file additional written statement in the suit to incorporate certain relevant facts as well as counterclaim to protect lawful rights of the defendant in the suit premises. Sir, forget about the counterclaim, my lord, at this stage. Sir, kindly see the written statement. Nothing. Para 10, that the defendant categorically denied and disputed the statements, para 4 to 14, which was mentioned in the plaint, and the total allegations are false. But why it is false? Nothing has been stated. That should have been stated. Subject to payment of cost, the counterclaim may be excluded. I can submit before your lordship.
Yes.
No,
What is
lordship,
the submission?
there is no lordship. Today trial has commenced. No doubt about that. Now, lordship.
There are two aspects. One is with regard to the incorporation of the counterclaim.
Yes.
That you have Ashok Kumar Kalra's judgment is there. It can. Now, the other thing is that Order 8, Rule 9 simpliciter, excluding that counterclaim part. Even if it is treated to be one under Order 6, Rule 17.
If you explain, lordship.
If your allegation is that, or your submission is that trial has commenced, so in order to overcome, that proviso, he has applied under Order 8, Rule 9.
Yes, lordship.
Even then, Order 8, Rule 9 is not automatic. That's subject to the leave.
Lordship.
So also the court can take into consideration also can consider the effect of the proviso while granting or refusing leave.
Exactly.
That's one part. That's the part of whether at all this will be exercised or not. Discretion will be exercised or not. Second part is that prima facie what it appears from the written statement, nothing was stated except
Lordship,
those.
they chose not to file, Lordship.
Yes,
Moreover,
so
Lordship, they have described themselves
now,
there as
Mr.
co-owner.
Chakraborty, only one thing, the object of what is the object of Order 6 Rule 17? If we can take it not under Order 8 Rule 9, also under Order 6 Rule 17, object is to decide the controversies in the suit. So
Absolutely
your case in the plaint is that you are the owner.
Lordship.
So his amendment is also to that effect, admitting that you have purchased.
No, Lordship. He is denying, Lordship. Kindly says.
I have not denied.
No.
Lordship,
Purchase.
kindly. He has denied. Lordship, kindly sees page
you are
22,
agreed to
paragraph
purchase by
12.
two brothers.
Yes, please allow me to make my observations clearly. He is not denying your purchase. He says there was an agreement that both of you will purchase, your husband and his husband.
That is his amendment.
Yes.
But in
that
the
is-
original written statement, what he has said kindly comes to
In the
paragraph
original
12.
written statement, he has denied that you are the
Lordship, withdrawal of admission also, Lordship.
original written statement. He has denied that you are the owner.
Categorically stated that the information of purchase is totally illegal and suspicious. The defendant
Illegal and
states,
suspicious.
states
Illegal and suspicious.
the original owner of the suit property was such and such by way of inheritance. The defendant was
Co-sharer.
co-sharer, Lordship.
So now the amendment is with an effect to state that there
Lordship,
was
it comes to paragraph 8 also.
8 of the written statement.
Yes, at page 21.
Yes.
That the defendant denies that the plaintiff had purchased the premises number such and such.
It is a matter of record. I have said so. If you have purchased, it is a matter of record.
But he has denied it. Categorically
No.
denied it.
And para 9
It
has
is
said,
a matter of record that he has not purchased. He has stated that the defendant denies that the plaintiff had not purchased the premises number such and such. It is a matter of record.
Your case is that you are the owner.
Yes.
He is a licensee.
Yes.
So you have filed a suit for eviction. Now, in the written statement, he claimed that he was a co-sharer and he's denied that you are the owner or your purchase he has denied. Now, in the amendment or additional written statement, by whatever name you call it, he sought to make out a case that he was a lessee in respect of the property in question.
Tenant.
Monthly tenant in respect of the property in question, and there was an arrangement that both of you will, your husband and his husband will purchase, but it was purchased, Ashit Ghosh purchased this property in the name of the wife. That's the case. So now he wants to only incorporate that fact.
True.
So with regard to your suit is for eviction of a license. For that, you have to prove your title also. So that is the relevant fact. What is the harm? These are the facts which are necessary for the purpose of deciding the
But
controversy.
Lordship, what prevented her from bringing these facts before Lordship?
That's not an absolute embargo, Mr. Chakraborty. Even proviso.
Something should be, Lordship, explained. Lordship kindly comes to her explanation, Lordship, at page 26.
Page 36. Puts the
26.
blame on the learned advocate.
No,
Change.
not a learned advocate also.
Yes. Says that. No, page 30.
26, Lordship.
Yes, 26.
That the sole defendant being widow is contesting the instant suit by filing written statement, paragraph 3, that very recently the defendant, before proceeding with further cross-examination of PW1, has consulted with one of the learned senior advocates who, on perusal of the original written statement, has noticed that relevant facts touching the defense of the defendant have not at all stated in the written statement.
What is the stage of the suit? What is the stage of the suit?
Further cross-examination of PW1 is going on.
Further cross-examination means further cross-examination on how many dates?
Lordship, at least 5 days he was cross-examined.
Yes, what do you say after the commencement of trial? How this?
But the proviso is not total.
Have you brought any judgment? No.
I have seen.
But
But
due
the
diligence,
proviso.
what about due diligence?
What? Which judgment you have seen?
No. The proviso, the apex court held that proviso is not altogether a bar.
But it should not be thrown away also, Lordship. We should
Show me
give
that decision. Which decision
exception.
says so? Proviso is not a bar.
My lord,
That I said
it
to
is a bar.
counter Mr. Chakraborty. Where is that
No,
decision?
proviso is a bar. But kindly see the language, my lord. Your lordship knows better than me. My lord, order 6 rule 17,
Yes.
kindly see, the language is not altogether a bar. Kindly see.
Do you have any decision in your favor?
I can, my lord, then kindly give me time. I can. My lord,
You have not brought that judgment, now you can.
my lord, the date is already fixed for further cross-examination. I will complete. I will complete the cross-examination. I will complete.
Sir,
Let the suit be disposed of.
how can it be? You are trying to state this fact. She has to get an opportunity to deal with your these amendments if allowed.
Kindly keep on the date. Let them file their rejoinder. Let the suit be disposed of at earliest. I am not standing on the way because I feel that at this stage I have a good case because I am a tenant. At this stage, let them file the rejoinder. The date is fixed on 8th of December. Keep on the date if required.
Yes.
I'm giving
Mr.
the
Court,
copy.
what they said.
They should give some explanation. At this stage, without even giving any explanation, they want to incorporate so many facts and which were already in their knowledge. They are not disputing that was not in their knowledge. And Lordship, nothing explanation. Only the learned senior advocate said that it has to be incorporated. He's
Chakraborty, the only thing is that written statement was very sketchily drafted.
True. They have chose to file it on that way, Lordship.
Chakraborty,
No
they
one,
have to, sir, litigants have to depend upon the experts. So this is the written statement.
But Lordship, what fault, Lordship, is that of
That
my
is
client?
why the written statement, the way it was drafted.
5 days, Lordship, I have been cross-examined. Thereafter, suddenly they think that some of the facts have not been stated. And now totally a new case.
Usually at the time of cross-examination, the senior lawyers are appointed.
And not only that, a new case. First
But the
is
best person to know that. So that is now the written statement, the way this written statement was drafted. Ashwin. Yes, where is Ashok Kumar Kalra's judgment?
But then, Lordship,
Where
exemplary
is
cause.
life?
Lordship, the fact that she's a lady, she's a widow, Lordship, that should not stand in the way. I am also a lady. The plaintiff is also a lady.
Where is Life Insurance Corporation judgment? Sanjeev Builders.
I have, Lordship, bought the latest 3 judges bench only.
On what?
On this, Lordship, Ashok Kumar Kalra I have brought.
Ashok Kumar Kalra is the 3 judges bench judgment.
Yes.
Followed in the subsequent 2 judge bench judgment followed. I'm not on that. On order 6, rule 17, Sanjeev Builders, where is that?
That I have not
2022, volume 16.
Not brought, Lordship. Let him also bring something, Lordship. Everything will be supplied by me.
So, Rai, you are not bringing those judgments.
Sorry, my lord.
This application.
Exemplary cost in that cases.
Number 17.
Yes. Lordship, item number 17, I am on behalf of the petitioner. Lordship, I prefer this revisional application with a prayer for expeditious hearing of the title suit. Lordship, one thing is
Stage of the suit.
Lordship, the stage of the suit is Lordship SRAD. Lordship, Lordship, I am coming. Lordship, I am coming. In 2022, the suit was filed and I am defendant petitioner. Lordship, kindly see date of issue was fixed on 25/1/2023.
Sir, SRAD.
I am coming, Lordship. Kindly give me only 1 minute, Lordship.
Yes.
Kindly give me only 1 minute. On 25/1/2023, the date was fixed for Q2. In that date, it was detected that upon pro forma defendant, the copy has not been supplied. That means SR supplied upon the pro forma defendant. Now I am asking myself, who is pro forma defendant? Pro forma defendant is husband of the plaintiff. And I am the principal defendant.
Take the appropriate steps there. Ashur.
Lordship, already
I am for the petitioner, my lord. My lord, shoot for declaration, recovery of
What is the
possession,
impugned order?
permanent injection. I am for the my lord, defendant number 1, 2, 3 before your petitioner, before your lordship, my lord.
Yes, what is the impugned order?
My lord, impugned order, third page of the certified copy, my lord. The
Yes, what is the
ex-parte-
nature of the impugned order?
ex-parte interim my lord, injunction was my lord, granted against the defendant number 1, my lord.
That you are challenging.
Yes, my lord. My lord, kindly see the page
Sir, please
14.
refer an appeal. This application under Article 227 of the আগেরটা তো পার্টলি অ্যালাউ
I am for the petition.
ওই যেটা ওই দুজন অ্যাপিয়ার করছে partly allowed or allowed in part যেরকম yes
My lord, I am for the petition.
yes
My lord, shoot for eviction of licensee. Shoot is at a PH stage, preliminary hearing stage. Plaintiff has concluded his evidence and defendant's evidence is to be yet to be started on the commission, evidence commission.
In the meantime, my lord, they filed an application. My lord, first of all, I submit before lordship, my lord, they filed a WS without any counterclaim. WS, it has been stated, my lord, that the name of defendant is Mahendra Singh.
What is the impugned order?
Just coming within 1 minute. Name of the defendant is
has been allowed. Only impugned.
I finish, sir. Let me finish.
He is the petitioner, yes.
Let me finish. Name of the defendant is Mahendra Singh. He stated in the WS without counterclaim, my lord. I remind, without counterclaim, he stated that his wife Champa Singh is the owner of the property by such and such. So should be dismissed. My lord, all the things are lying in the WS. Again, my lord, during the after commencement of trial, they bought a amendment application. Well, I filed the objection and stated that amendment application.
Where is the amendment application? That was allowed.
That was allowed.
Where is the amendment application?
Page 25. Malad, I categorically stated that Malad, the points of amendment which has been short for in the application is already existing in the WS. Just some exaggerated points is to be short for. Now, Malad, the question is, Malad, in the point number 17G, they have stated that Champa Singh, the owner of the property, is the absolute owner of the property. If that be so, Milord, if this amendment will stand, Milord, what will be the Milord, that will change the nature and character of property. Shoot itself. Shoot is a licensee. The court has to has to frame an additional issue that whether the Champa Singh is the owner or not. And if court finds my case failed, Champa Singh has to be declared with this ownership. But in a shoot of licensee, that will change to the shoot of declaration.
Where is the original written statement?
Milord.
Where is the written statement?
Milord, time. Milord, page number. Starting from page number 16.
16.
Milord, from para 15 onwards, if your lordship will have a glance, my lord can find the same thing is appearing there at. Same thing. But unfortunately, Learned Court Below has found that this is a subsequent event.
Yes. Where is the necessity for this amendment? These facts are already stated in the written statement.
Filer written statement was filed in the year, my lord. (2013).
Yes.
Thereafter, at that time, I mentioned categorical imprisonment that a writ petition has been filed before this honorable court.
Writ petition for what?
Writ petition, my name already been mutated in the bond of municipality. Thereafter, my name has been cancelled. Some name has been added. Against challenge, I have been mentioned. And on the it is by chance.
15 to 17 of WS.
Yes.
Continue.
In the meantime, my lord, honorable court directed the Baranagar municipality chairman to submit a report. And on the basis of the report, categorically submitted everything. And on the basis of the report and also the statement of the fact, my name has been recorded as the owner in respect of the premises number 15 and 16. This is the main thing. 15 and 16 is the trump card, premises number. But here, you will also kindly see the plaint. Plaint has been filed by learned friend. That is the mentioning. Plaintiff address is 16A Kali Krishna Tagore Road. I am residing at.
So you are trying to incorporate the facts of those writ petition, the orders passed, and the subsequent mutation of the property.
Mutation and in respect of the
mutation
tax
done. But they have stated in the WS there is
both of you argue at the same time, it's difficult.
After finishing, I start.
No.
Sir, please. No, my lord, what is happened? I have been paying taxes in respect of the entire premises in my name.
You are the owner, you will pay tax.
My lord. Now here, the suit, they filed the plaintiff residing in another places as the owner in respect of that place, which is not in connection with the present place. And the husband has been a eviction of license in respect of the one shop room. There is no shop room, my lord. Entire premises is my owner.
So therefore, the fictitious of the suit is pending more than 13 years. Nothing has been progress in suit. When this fact has been made, the learned court, my lord, kindly see the impugned order, last page, my lord.
Yes.
Has been allowed. Now, my lord, if I am the owner, I have been paid the municipal tax and also the khajna, and the porcha has been given to me. How the plaintiff claiming he is the owner? At the time of hearing, and my lord, kindly see, at the time of hearing, they deleted the name of the fathers of the plaintiff name from the Baranagar municipality. The father of the plaintiff name was deleted, and my name has been recorded. So, the principal law point is how the plaintiff is the owner. His father has been deleted from the record. He has been appeared, contested.
Just one line, my lord.
Application under.
You are stating that the suit is pending. My lord, for that reason, I obtained an order from the Honorable Justice Shampa Sarkar to dispose of this suit.
As earlier to, as earlier
That
to.
within 6 months, I have annexed,
Yes.
annexed his order.
I am also ready to hear the
Application under
matter.
Article
But
220.
that was the order not complied.
This application under Article 227 of the Constitution of India.
And expedite my suit, my lord.
Not in his civil division application. Let's call the next matter.
number 20 is my application.
The drama work was for me. I got this, I was the mediator for the court below.
Well, we have filed a revision application as well.
No,
But is a complete collusion, Malad. This is all about Malad DPS rule.
The drama is between.
Malad, the drama has been created by Malad all the defendants. Malad, this is Malad.
Starting from appearance, starting from where and ending where?
Malad, I am for the plaintiff. I am for the plaintiff petitioner.
You are the last one. No one to your right.
I'm in VC, Lordship. I'm in VC.
We are only for the plaintiff. We are only for the plaintiff.
But kindly, blood, our revision application blood is CO number.
Challenging the same order. Mujumdar, both are to be hard. If they also.
Then Malad, kindly keep it Friday week. Then Friday week. Friday week. Friday week.
Monday.
Mr. Mujumdar, why don't you stop Mr. Mitro?
Malad, there was no caveat, my lord.
Mr. Mujumdar, you may say that there is no caveat. Since he is appearing,
we will do so.
It was on a contest.
I understand, my lord. We will do so, my lord. Kindly keep it Friday week, my lord.
After Tuesday,
After Tuesday. Friday week.
In our High Court, challenging the
Mr. Mitro, you are supporting whom?
Son-in-law is wanting anything. If father-in-law wants to keep everything to himself,
Mr. Mujumdar, Mr. Mitro, considering the appearance of the parties, it has to be
very
posted
small appearance
after the vacation. It's a matter which is to be heard at length and fixing it after the vacation.
Identity.
This is the week, my lord. Only by the side. My lord, only my lord.
Weight is enough for the
Only the bodily mass may matter. But otherwise, it is okay.
And we are also ousted from the resolution.
Yes, but we have nothing, my lord. Kindly keep it then.
When your civil division application is coming.
In the suit filed by Mr. Aniruddha Chatterjee, challenging the very same.
Then
that's a separate issue. That's a separate issue.
Maybe if some of these issues may be interrelated.
Yes.
We are challenging the resolution.
Please hear me what I have proposed.
I cannot.
So then I think it's better this matter should be heard by these.
Lord, if your lordship hears it first, then if your lordship feels
it will be.
Your lordship hears it first. If your lordship feels it has to go there, lordship will send it.
Let us come back.
Both of you. You know what are the issues.
I am saying that it's.
I am not a party to that suit.
I was there.
I am not a party to that suit.
Mr. Mujumdar, you may not be a party to the suit.
Yes.
But the civil division application arises out of that.
That cannot be. No, not at all.
Different suit.
Your lordship, that's my lord. Our suit was before the court below.
Exactly.
My lord, maybe, my lord, but let us wait. My lord, let us kindly keep the matter on Friday week. We'll come back and
later, Mr. Mujumdar, this has to go before that.
Let us come back before lordship on Friday. Let us come back on 12th.
My application comes up tomorrow. I will place it. If they want to take it whenever they want to, I don't have a problem. My revision application is dated tomorrow. I will place it. I will serve. They are not on caveat. Even then I'll serve. There is no problem. But if they want it on Friday, my lord, I'm opposing because there's some design to that.
My lord will kindly keep it Friday.
Only what Mr. Mitro has said. He said that the judgment is expected next Tuesday.
My lord, we've got nothing to do. We've got nothing to do. We have We've got nothing to do with that. My lord hears it. If your lordship finds that there's something related, something to do with the other, yes, definitely. Certainly, court. I will quote my word.
That is from a writ petition or from suit before the original side.
How does it go there? Cannot.
No, but
go there. If the extraordinary powers are taken and the suit, that's what I'm saying. I don't want. I want my revision to be heard. I am going nowhere else.
Chatterjee, why are you getting agitated?
Mr. Mitra is trying to put words into my mouth. I don't like that.
Mr. Chatterjee, you are
Saying it's my suit.
Chatterjee, you are a senior advocate, you are a seasoned advocate.
But I don't know about
Just
Mr.
make
Mitra.
one humble
About
prayer.
all you.
And only one submission, my lord. I am
I appreciate that.
the petitioner, I am the plaintiff.
Follow.
My only prayer before Lordship is that they have served a revisional application upon us, challenging the self-same order.
That's it.
My lord, let both the revisional application be tacked together and kept on 12th.
Cano.
Yes.
My revision application that I don't want it to be tagged. I will move it tomorrow. I will move it tomorrow.
Then, my lord,
Mr. Roy, the drama that's going on.
Mr. Roy, tomorrow Mr. Roy is at an inconvenience. My lord, Monday or Tuesday.
Mr. Roy is appearing for the same party.
Yes, my lord.
Mr. Chatterjee is opposing
My
that.
lord, kindly, my lord, there has to be some weight on this side. I don't have to take balance. There has to be some weight on this side.
You mean to say your weight is not enough?
Not enough. Not enough. My lord, kindly keep it on Tuesday or Wednesday.
Monday. Keep it on Monday. I don't have a problem.
Tuesday.
Achha, Tuesday. I'm in some difficulty. Monday.
Wednesday.
Bobby. No.
Wednesday.
We all decided on Tuesday.
Tuesday. I mean.
बुधवार को Wednesday.
Achha, Monday.
Monday, my lord, kindly keep it on then Tuesday, my lord, kindly keep it on Tuesday. My lord, if they are so inconvenience, let it be on Tuesday.
अब যেহেতু আমার অসুবিধা সাথে Tuesday.
Well, Tuesday. Then Wednesday, my lord. Mr. Roy, both Mr. Roys will not be there on Monday.
No, Mr. Roy, my lord, I don't know whether he will be
Mr.
able to hear.
Roy, Junior Mr. Roy has shifted his residence from Calcutta. Are you aware of that?
No, I am not
He has
aware.
got a new residence.
Mr. Chatterjee is supposed to show his inconvenience on Tuesday. In which residence is going on?
Shifted his residence.
Mr. Roy, yes.
Shifted his residence. We have not been
Permanent
informed.
residence, he has shifted.
We have not been informed.
জলপাইগুড়ি
That I do not know. That
or Delhi. But জলপাইগুড়ি, I understand why. Can't say, but
But kindly keep it on
Mojumdar,
Wednesday.
senior advocate, appears for the
Wednesday, man.
petitioner.
Wednesday.
Mr. Anito Lanet, senior advocate, appears for the
4 and 5. 2, 3, 4.
2, 3, 4 and
They are all the same.
we are appearing.
you are also a party in this.
No. This is with respect to DPS Newtown in Ruby Park.
DPS Ruby Park.
Teachers, everybody will come in. What the teachers have got to do, Miller, with
Mr.
respect to the
All right,
class.
Mr. Mitchell Lanet, senior advocate, appears for the opposite party. 2, 3, 4 and 5.
We are probably one.
No, opposite parties.
But
Mr. Mojumdar, please ascertain who is Mr.
Mr. Mitro, I believe, is appearing for OP number 224. I believe
2, 3 and 4.
I believe.
তারপরে লিখুন Mr. Chatterjee Lanet, senior advocate,
225.
I am for 6.
appearing for the opposite party
1
numbers.
and 6.
Opposite party numbers 1 and 6.
1, 6 and 7.
Society also. Mr. Chatterjee,
One is not society.
I don't have the copy.
Well, one
know your client.
Seeing it now from.
I tell you,
1, 6 and 7.
Well, I tell your lordship one thing. So far as I
good ground to release this matter.
well, I do not do that. Only one
The
objection.
state opposite parties have filed an independent civil revision application, which is expected to appear in the list tomorrow. First up, as jointly paid by the Lanet senior counsels for the respective parties, list this matter on Wednesday.
Wednesday, my lord. Wednesday, my lord.
Let it Tuesday. I think one
Tuesday,
Monday, another Wednesday. I think it's the courts.
Tuesday, my lord. Then Tuesday. No question. Tuesday.
No, I am saying I am on
Tuesday.
First keeps it on Tuesday, there is a difficulty. Keeps it on Monday or on
Wednesday. Wednesday. Well, only one submission may be recorded on behalf of the plaintiff. So far as OP number one, is concerned. So far as OP number one is concerned.
Mr. Chatterjee, learned senior advocate appearing for the opposite party number 1, 6 and 7
That is
submits,
one I am disputing.
assures this court that the civil revision application filed by the said opposite parties, that the copies of the civil revision applications filed by the said opposite parties shall be duly served upon all the parties prior to the next date of hearing.
And also, Mr. Mujumdar, sir, I have not been served with that also.
The learned advocate on record of the petitioner is directed to serve the copy of this civil revision application
On the society, defendant number one.
upon all the opposite parties.
OP number one has dual personality.
Upon the opposite party numbers one, now upon the learned advocates representing the said opposite parties. Yes, please give your either email or addresses of your respective advocates on record for representing. Because there is no caveat.
But I do not know the opposite party. I am for the defendant number one.
Under the same.
Defendant number one is the opposite party number one. Yes, we'll do so.
Yes, may I now take your
তুই কোন দিকে ছিল তখন? আমি তখন রাজারহাট যাচ্ছিলাম।
May I have Malat's kind leave Malat to mention whether I was seeking for two leaves, Malat, two civil revision or applications, Malat, to file it without the certified copy, Malat. This grave
urgency.
the urgency, Malat, is that I'll be out of my hotel business. My hotel, somebody has taken it over by dint of a forged document.
What is the order and the challenge?
The challenge is that of an appellate court's order, Malat, wherein I've applied for this. The order is dated 26th of August 2025. I've applied 25th of August 2025. I applied it on 26th of August. I've not got it as of now, Malat.
Yes.
With the civil revision
The
application.
server copy.
Server copy, Malat.
Leave to file with the server copy.
2025, not on Thursday, not Thursday. The order
I could not hear you.
CO number 3168 of 2025, Millard. It was heard on last Thursday. The order is yet to be uploaded, Millard.
Keep the number. Yes, they can in order. Yes, call the list.
Item number 4.
But we mentioned, but today tried to mention, but today is a holiday.
State government has declared it as a holiday.
Yeah,
I don't know why.
Now, during the recess, I was informed that there is also sectional holiday of our court.
Karam Puja.
Sectional holiday. Yes, yes.
Karam Puja.
Sectional holiday of our High Court also. No, only thing is that I was given an impression that it will be accepted. That is why I asked you to mention.
Sir, we
So,
can come back
Well,
tomorrow.
we can come mention in the
in
morning.
So I'm doing one thing. I'm keeping it on Monday.
Very good.
So try your luck. Mention it on tomorrow.
Actually, I have a personal difficulty from Tuesday onwards.
Tuesday onwards.
Monday কোনো কারণে যদি না হয় না আমি আর kindly keep
Tuesday onwards you will not be before the vacation.
No, I will come back, but the situation is such manner that I cannot request them to wait. If we come back tomorrow at 2 p.m. We will mention in the morning. We will apprise your lordship what has happened.
Tomorrow,
if your lordship sees,
I have no problem. I have no problem. Your lordship can keep it on Monday morning. You can, lordship can keep it.
let us একবার কালকে থাকুক, যদি না হয় মানডে হবে।
Ask your counterpart also to be present.
Yes, no, in fact, he was present today, he'll go tomorrow. There is no problem. He is present in court today also. I'll just inform.
10:30
কোনো নোটিশ দরকার নেই. I am taking note.
কিছু দরকার কালকেই
দরকার আছে আমাদের one line malot DVC after all.
কালকে 2টোর সময়তেই রেখে দেবেন।
ঠিক আছে।
Item number 21.
Yes.
Lordship, I am on behalf of the petitioner. Paying for expeditious disposal of the maintenance suit.
Of the maintenance alimony application, this
Yes.
case.
Yes.
Who are you?
I am petitioner wife.
You are the wife.
Yes.
This application under Article 227 of the
But I am for the petition. That the decree holder is a petitioner before your lordship took file on the ground of subletting that was decreed way back in 2014, my lord.
Concerning properties, I do not have any
But
difficulty.
this matter, my lord, your lordship has not appeared. I inquired. In effect, my lord, this matter, one of the issues, my lord, your lordship has already, my lord, hearing a revisional application.
Yes.
My lord, kindly takes up, my lord, the application filed in the execution case under Order 21, Rule 99. That is, starts at page
What is the
34.
impugned order?
Impugned order, my lord, by virtue of which amendment after 11 years, amendment of this miscellaneous case is being allowed after commencement of trial at this stage when the cross-examination is going on.
Amendment of Order 21, Rule 99.
99 application. I will show before your lordship, Lord, how frivolous the application is. Lord, kindly takes up, Lord, once for my satisfaction, the prayer of the, Lord, page 57 of my lord's brief, the prayer made under Order 21, Rule 99. I will not place before your lordship. Kindly have a glance of the prayer. Lord, your lordship will get, Lord, what is, Lord, the independent right tried to be canvassed.
Yes.
It's become, my lord, now an Order 9 Rule 13 application can be filed, my lord, couching, my lord, the giving quotation as Order 21 Rule 99. Exactly what has been prayed here. Lord, kindly takes up now the amendment application, page 71, it starts. The schedule of amendment. Page double. Lord, it starts, Lord, 89.
89?
Yes. Lord, the repetition and reiteration of the proposed schedule of amendment is there in the application. And the due diligence part 2 paragraph I will show before your lordship. And I will request your lordship to compare with the original application under Order 21 Rule 99. All the existence of all these facts already been pleaded.
The শুধু miscellaneous case.
Item number 23.
Time for the petition. But opposite party plaintiff filed a suit for a declaration of permanent injunction of the property. But defendant number one died on 22nd December 2021.
What is the impugned order?
Impugned order is last order, but before that, may I come to page 20, page 12, man. Which page 12? But they have filed an application for substitution, but without paying for setting aside the abatement. Because
give me a minute. Who are you? You are the plaintiffs.
No, I am the defendant number one. And number two is RR department. So we
all right.
Defendant number one.
Yes, so you wanted to recall the order dated 2nd of August 2004, by virtue of which the substitution was allowed.
Allowed, but without setting aside the abatement.
When what is the date of death?
12th December, 22nd December 2021.
21. So did you disclose this date of death under Order 22, Rule 10, capital A?
What happened? The plaintiff.
No, I'm asking you. Did you disclose? Did you comply with Order 22, Rule 10A?
I disclosed this, but this was disclosed before the honorable. They filed a revision application.
Before the learned trial judge, did you disclose?
No, I have disclosed before the honorable High Court.
Then
yes, sir.
Also, you did not disclose the date before the Honorable High Court.
Yes, but I handed over a copy of the death certificate.
Maybe, but it was not recorded there. But what prevented you from disclosing that before the learned trial judge? You have not complied with Order 22, Rule 10, capital A.
What my prayer before subject of consideration. This is the ground for constitution of delay, no doubt. But this is a delay. The court can condone the delay because of this fact. But they have to file a section application. And they have not filed any section application.
Sir, one thing, the time to run for the substitution from the date of death. Till date, you have not disclosed the date of death. So there is no question of abatement unless the date of death is known to the learned trial court. There is also a judgment to that effect.
1 and 2 petition of the Procedural. Partition suit, my lord. My lord, initially, my lord, suit was filed,
the
my lord.
plaintiff.
My lord, I am the defendant number 1 and 2.
Defendant number 1 and 2, yes.
Petitioner before your lordship.
Yes.
Partition suit filed in the year 2012. My lord, 20.
They are for repairing rejected.
My lord, repairing rejected. Initially, my lord, in the year 2015.
Where is the application for repairs?
My lord, that is, my lord, page. My lord, 27, Annexure C. My lord, initially.
Page 27.
Page 27, my lord. Relevant portion, my lord, 28. Repairing application, my lord.
Yes, any
no objection. No objection. They have not filed any, my lord, written objection, my lord. Only oral submission. And court held that, my lord, as there is the, my lord.
What is the stage of the suit?
Nothing, my lord. Plaintiff so cause, my lord. My lord, kindly see the order. My lord, kindly see. Not taking steps, my lord. My lord, taking the advantage of the interim, ex-parte interim order, my lord.
Have you filed any application for local inspection?
Yes, that has been held, my lord. Commission
local inspection held.
Yes, my lord. My lord, after considering the local inspection report of the my lord advocate commissioner, my lord,
yes.
The learned court was pleased to allow that application in the year 2015. That order I have annexed, my lord. That is, my lord, page 23. My lord, kindly for a look, my lord. Page 23.
By the order impugned.
And my lord, see the condition of the
impugned.
Your lordship, I am appearing on behalf of the petitioner.
Petitioner, yes.
This is an application for
service on the learned advocate.
No, service of the upon the opposite party as well as upon the learned advocate.
So many, my lord. So
not only, no. Service upon the opposite parties as well as upon the learned advocate for the opposite party.
lordship, this is an application for expeditious hearing of a suit for eviction of a licensee pending before the 5th Civil Judge Junior Division at Alipur. Your lordship,
what is the stage of the suit?
Last order has been
framing of issues.
Framing of issues, your lordship. 2 years has passed, your lordship. Suit has only proceeded for payment of cost for acceptance of written statement. Lordship. Dates are fixed after 3 and 4 months. Lordship.
Payment of cost for acceptance of what can be done? You are not accepting the cost. That is why repeated
They are
dates
not
are being
paying.
fixed.
Lordship, kindly see the dates that are being fixed for next.
This application under Article 227 of the Constitution
26, I appear for the petitioner. So if the petitioner, my lord, challenge the order, my lord, dated 5th July 2025, my lordship will find it at page 70. But totally, my lord, procedural, my lord.
What is the order impugned?
My lord, on the date of verification of the execution, my lord, petition, my lord, on that date, my lord, issue of writ, my lord, has been directed. And my lord, the bailiff was directed to, my lord, break open the padlock. Although no attempt was made by the bailiff for, my lord, to go to the suit property and to give, my lord, the execute the writ of possession. My lord, within a span of 1 month, entire execution proceeding has been completed. My lord, I filed the regular appeal, which cannot be taken up within this, my lord, short period. My lord, kindly have a look. Page 69. That is the date for verification.
When have you filed the title appeal?
When
have you filed the title appeal?
Lord, district judge.
When?
My lord, before, my lord, filing of the execution case, my lord. Before filing of the execution case.
I'm asking you the date, sir.
My lord, date actually, my lord.
Did you file an application for stay?
Yes. Yes, that was, my lord, even before the executing court also.
In the appeal court?
Yes.
When is the execution application fixed for hearing?
My lord, that has been, my lord, executed.
What is the suit property?
Suit property, my lord, shop room.
Yes, New Raghunath Market.
My lord.
Yes,
Raghunath
deposit the occupation charges.
But I am out of possession.
Now you have been ousted.
Yes, that is my case, my lord. My lord.
So I can do one thing. I am expediting the appeal. Nothing. You cannot be restored back now. So,
my lord, kindly appreciate, my lord.
I am expediting the appeal,
Yes,
sir.
My lord, I do bow down to
What
the
can be done? Now,
my lord, kindly only one document. My lord, kindly page.
When have you been dispossessed by executing?
My lord, on my lord, 14th July.
14th July. Now we are in September. So I am expediting the.
My lord, only one document. My lord, kindly page 69, my lord. My lord, how, my lord, this has been dealt with? Lordship, kindly have a look, my lord. Last order, my lord, 30th June, my lord. Due to resolution of the local bar, cases adjourned, fixed 5/7/25 for verification. My lord, 5/7
filed the title appeal.
My lord, I filed the title appeal, my lord, sometime in the month of June.
June of
2025.
June of 2025.
Sir, very unfortunate because the suit was not properly represented.
Now
by
what can be done? Now the possession has been taken. I am expediting the hearing of the appeal.
In the meantime, no, my lord, third party interest is created because my lord, your lordship knows.
Make that application before the appeal court. This application under Article 227 of the Constitution. What is the number of the appeal?
Well, only the title suit number, title appeal number.
Same day.
Same day, same day.
What is the number of the suit? What is the number of the appeal?
Title suit number, my lord.
Put it in a, please put it in a piece of paper. Title suit and number. Which paragraph you have set it? The title.
Well, in the impugned order, it is page 70, my lord. The
page
70.
70.
Yes.
Oh, title appeal number 82 of 2025. It is also pending before the.
My lord, my lord.
Page 70 তে না দুটোই আছে টাইটেল সুটের নাম্বারটা
Same day, my lord, it has been, my lord.
You are safe from paying occupation charges. That much I can say.
I am ready to pay occupation charges. But
How you are saying?
Very unfortunate, my
When
lord.
occupation charges will be fixed, you will be saying no.
82 years widow lady, my lord, that has been, my lord, without.
Next.
Deeply obliged.
Yes.
The defendant is the petitioner.
Yes.
Defendant is the petitioner, my lord. Challenging an order whereby, my lord, 2 points, my lord, I will urge. First point, my lord, the court has not even looked into. My lord, that is with regard to, I have said, my lord, the commercial suit which has been filed before the.
What is the impugned order?
Yes, my lord. My lord rejects my 2 application, my lord, under Order 7, Rule 10, and my lord, Order 7, Rule 11.
Order 7, Rule 10, Order 7, Rule 11.
Both are of same nature, my lord. Both was filed for
So
transfer
according
of
to you, the court lacked the jurisdiction.
inherent jurisdiction, first point.
So it has to be returned.
Returned. Now, my lord, why I say though, my lord, kindly takes
Because
up
before the commercial court.
Commercial court, Alipur.
Yes. What is your point of jurisdiction?
Point of jurisdiction, the first point is, my lord, it ought to have been filed before Rajar. Because the property, my lord, upon which the litigation is going on, is situated in Kashipur. Now, my lord, it is admitted position that Kashipur is, my lord, in North Chobbish Pargana, not in South Chobbish Pargana. Now, my lord, what happens, my lord, the defense which is being taken, my lord, they say Shialda court, my lord, is having the determination over Chitpur PS. Now, my lord, as Chitpur PS has gone to Shialda court, and Shialda court having jurisdiction, my lord, having the district judge in Alipur, being South Chobbish Pargana, therefore, Alipur commercial court will have jurisdiction. My lord, in my humble submission, that is not how, my lord, the commercial courts are having jurisdiction. My lord, commercial courts are having jurisdiction, my lord, takes up the notification, which is at page 137.
Of the learned trial.
Has not given any reasoning. Court has not touched that.
Show me your point you have raised.
Yes. From the impugned order, I show, my lord.
Yes, from the impugned order. What is the suit for?
My lord, suit for, my lord, eviction.
Eviction before the commercial court.
My lord, there is another point, second point, which court has diverged into, and my lord has answered, rejecting my contention. Now, my lord, the first point, my lord, I have raised it, my lord. Kindly takes up impugned order, my lord, and my lord takes up the second page of the impugned order.
Second page.
Yes.
This is the order dated 2nd of August 2025.
Yes.
Yes.
Now, my lord, kindly takes up besides the above.
Yes.
Besides that, the defendant has also submitted the suit property outside the jurisdiction of this court. Therefore, as the instance filed for recovery of possession of this property on the same ought to have been filed with the court within whole jurisdiction the property is situated. So, in view of the above reason, the defendant have prayed for rejection of the plaint in the instance suit. Plaintiff respondent has filed affidavit in opposition to the aforesaid application. In the said opposition, plaintiff respondent has contended the ground as raised by the defendant in the instant application regarding the territorial jurisdiction of this court to try and entertain the suit before this court is fully misconceived as the lease in relation to the suit property lying within the jurisdiction of police station Chitpur can be filed before the Shialda court complex, which is evident from the information obtained.
So this is within the police station Chitpur.
Police station Chitpur. There is no doubt.
Yes.
Police station Chitpur, my lord, is having Shialda court is having jurisdiction over Chitpur PS.
Yes.
My lord, now my lord, Shialda court is enjoying, my lord, district judge sitting in Alipur, being South Chobbish Pargana.
Yes.
So commercial court says, as the police station is in Shialda court, so therefore I will have. My lord, I say, my lord, this is a misconception because commercial courts are having determination district wise, not police station wise. My lord, what happens, my lord, suppose, my lord, I tell you an example, my lord, Shialda courts were having determination about police station, Barakpur, Nimta, airport. My lord, after formation of Barakpur court, having district judge, my lord, by judicial notification, all these PSs and respective cases has been transferred to Barakpur court now. So, my lord, by PS, my lord, district cannot be determined. And my lord, the notification by which my lord commercial court is having determination is district wise. Kolkata has city civil court, south my lord Alipur, north Rajarhat.
So according to you, this is situated within not 24
Not
Parganas.
24 Parganas. So, my lord, this, my lord,
show me the plaint.
Yes. Kindly takes up, my lord, page 18. First page is the description of the property, Kolkata 2. First paragraph.
Page?
Page 18, my lord.
Page 18. Please give me a minute.
Paragraph 1.
Yes.
Khagendra Chatterjee Road, previously known as 4 Gun Foundry Road, Kwasipur, PS Chitpur, Kolkata 2.
Yes.
So, my lord, this is north.
This is
North 24 Pargana.
Where from do I get that?
My lord,
not 24 Parganas.
absolutely. This is my contention, my lord, and I've searched on internet also. My lord, internet says it's Kolkata district.
Then
internet says Kolkata district. But, and my lord, by logic,
Kolkata district do not have any commercial court.
Now city civil court is there. Kolkata district has. Now city civil court is open. And my lord, the notification, if my lord takes up for once, my lord, which I rely upon, my lord, kindly takes page 137.
Where from do you get that it is within Kolkata district?
My lord, this is, my lord, Kwasipur, my lord,
Kolkata-
I tell you, Kwasipur is, my lord, that beside the Hooghly River, after, my lord, Gali Street, my lord.
Kolkata district has been.
My lord, kindly sees. My lord, this is no Wikipedia, there is no, my lord, absolute. But
it's no district
today,
as Kolkata
my lord,
district.
Chitpur PS is under North Police Division.
I have to read the history of Kolkata then.
No, my lord, first line says, my lord, Kolkata district. That's, I have searched the Kolkata history.
History of Kolkata.
Absolutely.
From Sutanuti.
Yes, my lord. Absolutely. My lord, otherwise I cannot find which is Kolkata district or not 24 Pargana.
No, Kolkata district, can you show me any notification with regard to constitution of a Kolkata district? Show me.
Yes, yes, yes.
Show me.
My lord, this is the last one which was given. My lord, kindly turns to page 137 first prior to this. My lord, 137 is intact, but after.
Sir, you have made micro from micro. This,
No, my lord, this is the, my lord, printout coming up. Not micro from micro.
Print says so. Double micro. From a micro, you have made micro.
This is after formation of city court, my lord. Kolkata has now, my lord, has its own.
No, two commercial courts at Calcutta. It does not say where do you find Kolkata district? Where do you find that?
My lord, Kolkata district will. That's why I say, my lord, kindly takes a 137.
Page 137 of the
yes.
civil division application.
Yes.
Which volume?
My lord, one. Actually, my lord, volume 2.
I have been given 2 volumes. You may have been given 1 volume.
Volume 2, my lord.
Yes.
My lord, this is how, my lord, commercial courts are having determination by gazette notification. May I just place it in exercise of power conferred by
Mr. Chatterjee,
my lord.
here the district of Kolkata does not find it.
That's why, my lord, as there was no commercial court, Kolkata then formed. Now, my lord, after city civil.
No. This is not with regard to commercial court at Calcutta. This is a notification concerning all the districts. You will be finding the districts here. Now, certain districts have been allocated to certain commercial courts. Here you will not find the mention of the Kolkata district.
Not absolutely.
Show me the constitution of the Kolkata district.
That's why exactly, my lord, it says that notification in 2020th March, which I've handed over this recently, where it says Kolkata will win the original jurisdiction which Kolkata is enjoying before the court. So ordinary original jurisdiction.
Show me
that. Next page, can you turn over, my lord?
Next page, yes.
The added D. Insertion of D.
Insertion of
D. May I just, my lord, hand it, check.
No, E is there. Where is
E? After D.
In case of commercial. Division. No, the local limits of the jurisdiction of commercial court at Calcutta.
Yes.
The areas included within the original civil jurisdiction of the High Court at Calcutta.
Yes.
No, this is within the jurisdiction of the commercial court at Calcutta.
Correct. So Kolkata.
How do you say? No. How do you say that this suit property is situated within the Kolkata district? I'm at that.
Milord, I say it's not 24 Pargana because if I look into the original side determination of the jurisdiction, Milord, as I find from Milord the original side rules, I find Milord it ends at Galip Street. Milord, one pillar is taken from the Hooghly other side.
Conveys to be made.
Milord, this is
I'm appointing you, Mr. Chatterjee.
Exactly, Milord. Court has not gone into that point. Admittedly, Milord, Kosipur is not South 24 Pargana. Milord, it is. My contention is this notification doesn't say jurisdiction will be by the thanas or the police stations. It has to be by the district. So the court has to say, if at all has to say, that it is district South 24 Pargana. Kosipur falls under South 24 Pargana. It cannot say as Shialda is enjoying South 24 Pargana, I will enjoy South 24 Pargana. But this is where I am saying that this is absolutely wrong. Today, if my lord says Kosipur is in district South 24 Pargana, then court has to say it is within district South 24 Pargana. Court cannot say that it is PS Chitpur.
So this property admittedly falls within PS Chitpur.
PS Chitpur, absolutely.
So do you mean to say that if PS Chitpur is within which district?
Not 24 Pargana, because it is under the
Chitpur.
Yes, because it enjoys not under the North Police Division. It is not under South Police Division.
Where have you made that submission, Mr. Chatterjee? Please show
Milord,
me.
I have made it not 24 Pargana, that I have made it. Kindly take up, Milord. Page 117, my application.
Page 117.
And Milord, 119, the page, Milord, paragraph 6.
Second volume.
Yes, Milord, second one.
Yes.
Paragraph 6.
And how that has been dealt with?
Yes. Now, my lord, that has been dealt with. If my lord takes up the second volume and refers to, my lord,
the impugned order.
No, not impugned order. In the petition also they say. In the objection.
No. I'm asking you how it has been dealt with in the impugned order.
Exactly, that paragraph only, which I have shown. Nothing more, nothing less.
Please show me again.
My lord, internal page 2.
That is in the first volume. Why are you annexing the certified copy in the first volume, thereafter the second volume?
Lord,
that's also the rule.
That he says, my lord, he was said to do that in commerce in the department.
Yes, which paragraph?
My lord, internal page 2, the paragraph 3rd or 4th paragraph in the said opposition. My lord, from top, 1, 2, 3, 4th paragraph in the said opposition. My lord has got it, my lord.
Paragraph 2. Page 2, page 2.
Yes, my lord.
No, earlier, prior to bifurcation, Shialda court has jurisdiction of north and south as
well. Both, exactly. Milord, this is my point.
So now there has been a bifurcation after the Barakpur court has been
exactly.
Now the not 24 Parganas matters went to
not by north. It has, Milord, I have seen that notification. It says PS Nimta Airport Dom will go to Barakpur. So Milord is always PS. It's not district wise.
No. It's PS.
PS. So therefore, by PS, Milord, district cannot be determined.
No. But do you have that notification?
Milord, I can get it because I have in my chamber. Because I tell you, Lordship, what is happening. Milord, Judicial Department issued a notification saying that the 3rd court and 4th court of Shialda having jurisdiction over these PSs will no more have jurisdiction and they will be transferred to Barakpur 3rd and 4th court.
Yes.
Respective.
What is the basis of this bifurcation? Basis will be on the basis
No,
of
but
district.
basis as it was given, the litigants should be having convenient court at its own place. So therefore, litigants staying at Barakpur were traveling to Shialda.
But this
So, my lord-
bifurcation, which police station should go, must be on the basis of district.
That judicial department notification doesn't contain. It says, my lord, as per the order, my lord, of the judicial department, a notification is issued. Well, that is what it says. I can produce it because I tell your lordship, the judicial interpretation of the notification is also on a representation I have drafted and made it to the Chief Justice.
Mr. Chatterjee, learned yes.
My lord, item number 29,
Lord,
Mrs.
may I
Shabana.
take back that notification handed over.
But mega,
Larger, enlarged copy.
macro, not micro. 2 times micro will come to the original. Yes,
My lord, in this matter, Mrs. Shabana Hasini is appearing, my lord.
yes.
Due to her illness, she could not come to court today. my lord. I am praying for not today. my lord.
On the prayer of the learned advocate for the petitioner, list this matter. Call the next matter.
Your Lordship, Your
Yes.
Lordship, the petitioner being the plaintiff filed one suit for declaration of right title interest and permanent injunction. Now, Lordship, initially my ad interim injunction was dismissed. I preferred appeal, and order of status quo was granted by the appellate court. And as the opposite party, the defendants were still continuing with the construction, I filed one application under 151 for police help. That has been rejected, Your Lordship.
Ad interim order.
Yes, Your Lordship.
Ad interim order rightly rejected.
No, Your Lordship, in my injunction application, I stated that they have cut down my rain pipe and were making the construction in such a way that anytime my house would fall down. And on that basis, the status quo was granted with in regards to nature and character of the suit property. But even after the passing of the interim order, Your Lordship, they are carrying on with the construction.
This application under Article 227 of the Constitution.
I'm for the petition, my lord.
Yes.
I'm like praying for like expeditious disposal of the suit, my lord. Already PW1 was been examined, my lord. Then, my lord, then after that, my lord, the plaintiff has filed one amendment application, my lord, and that is
Amendment application pending or disposed of?
no, my lord, it is still pending, my lord.
What is the next date fixed for hearing of that?
My lord, it's like my date, my lord, is going from last 2 years, my lord.
What is the next date fixed for hearing of this amendment application?
My lord, it is 19/9.
19th of September.
Yes, my lord.
For amendment application.
My lord, yes,
It's
my lord.
otherwise ready for hearing of written objection filed.
Yes, my lord,
This
written.
application under Article 227 of the Constitution.
Item 32 and 33 for the petitioner. This is a case, my lord. 7N and 7.2, my lord, application, my lord.
7.1?
7.1 and 7.2.
Yes.
I am for the landlord, my lord, if your lordship, that is plenty.
Yes.
Should file, my lord, 2019. And the defendant, my lord, appeared, my lord, 18 January 2020. But he never filed any application 7 on 7.2. He filed an application for supply the copy of the plan. Thereafter, he filed the application 7.1.7.2 after 4 years, that is 2024, 27 February 2024. And my lord, I made an application. I also written objection to the 7.1.7.2. And he deposited the rent controller. When he appeared before the Lord Court, my lord, the deposits of the rent controller, my lord,
is not valid. But my lord, 7(1)(b) says that if the summons was not served and if he appeared, then my lord, within 1 year, 7(1)(7)(2) ought to file within 1 month, within 1 month from the date of appearance.
Show me the order date 27th of February 2024.
That is the last page, if your lordship.
27th of February 2024.
Yes, my lord.
That's the
Last impugn order, my lord, if your lordship. I also challenge.
The suit was proceeding ex-parte.
Ex-parte, because my lord, the suit was not appeared, my lord, before that. Before that, my lord, was not appeared. And that after, my lord, he appeared, my lord, he made an application to start
you are plaintiff.
Yes, my lord, yes, but my lord, no, kindly, my lord. If he have to file 7A, kindly, my lord, 7(1)(b), my lord, if your lordship. Kindly, the provision is there, my lord, if your lordship will knows very well.
No, you can place that. Yes.
Yes, my lord, if your lordship, kindly see. 7(1)(b), if your lordship.
Yes.
Seven 1A, if your lordship, and 7(b).
Yes.
On a suit being instituted by the landlord for eviction of any of the grounds referred to in subsection 6. The tenant shall, subject to the provision of subsection 2 of this section, pay to the landlord or deposits with the civil judge, all area rents such and such, and calculated at the rate of such and such. That is, my lord, civil judge or the landlord to pay. And 7(b), my lord, such payment or deposit shall be made within 1 month from service of summons on the tenant, or kindly say, my lord, or where he appears in the suit without summons and being served upon him within 1 month from date of appearance. But within 1 month from date of, he appeared, my lord, on 28 January 2020. He never filed an application 7172. He filed an application 2024. Therefore, my lord, the deposit before the rent controller is a bad deposit. He appeared. That's my lord.
What is the suit for?
Suit eviction.
Eviction I follow. What ground?
Ground for defaulter, reasonable requirement, and additional alteration. That's my lord. If you lordship, my lord, the whole deposits is bad deposits. And my lord, kindly say, my lord, if you lordship, my lord, the provision is a mandatory 7(1)(b), if you lordship, my lord. He ought to file 7 and 7 within 1 month from date of appearance. He appeared 21 January 2020. That's why, my lord, if you lordship, kindly, my lord, please to all further proceeding, if you lordship, and my lord, and the order, impugn order.
Own suit to be stayed.
Yes, my lord. Other, my lord, order is kindly, my lord, order kindly. The impugn order, my lord, is totally bad, my lord.
Where is the explanation for the delay?
Delay, my lord.
Challenging the order dated 27th of February 2024.
But my lord, paragraph 8, if you lordship,
yes,
that he is, my lord, 96 years old, if you lordship.
That
but
cannot be
227,
that cannot be a ground because he is contesting before the that cannot be a ground. So,
and I have challenged, my lord, 2 orders, 7(1) and 7(2).
Cannot be in a single civil division application because earlier
if your lordship, my lord,
that has to be. If you are so technical, that has to be taken.
But if your lordship, kindly, my lord, I shall file, my lord, application if your lordship, my lord.
Application under Article 227 of the Constitution of India is at the Is same order. Suit number will be only changed. Order dates are same. Service of the copy of the plaint same. Next the same order. শুধু suit number টা দেখে নেবেন. Yes, next. Yes.
And on behalf of the petitioner, and the suit was filed in the year 2014. And after
What
that,
do you want?
praying for early disposal of the matter.
Suit pending from 2014. What is the suit for?
Suit for declaration for right title interest of the petitioner.
It's at the evidence stage.
Yes, evidence is the
PW2's evidence is on 3rd of November.
Yes.
This application under Article 227 of the Constitution of India is at the instance of
Madam, 35, I am the
Yes.
petitioner, madam. Madam, I am the judgment debtor, my lord.
Yes.
My
What
lord,
is the order under challenge?
23rd, 23/7/2025, my lord.
Order dated
Order dated 23rd July 2025, my lord.
23rd July. Yes.
My lord, the judgment holder accept the decree hold, my lord. Then they filed an execution, and the execution proceedings, my lord, passed the ex-parte order, and I am the judgment debtor, my lord. Can you kindly release?
Yes. What is wrong in the impugned order?
My lord, the impugned order is just a not to create any disturbance, my lord. But
Yes.
my lord, my I am the judgment debtor, my lord. That's why the only hearts to the decision of the court, my lord. They go to
But you
the
have violated the order of injunction. Order 21, Rule 32, civil imprisonment.
yes, my lord.
So what's wrong in this order?
My lord,
If you are violating the order of injunction, that's the remedy.
my lord, kindly kept in abeyance, my lord.
Why?
That civil imprisonment,
No,
my lord.
cannot be kept in abeyance. You have been taken to custody.
Yes, my lord.
How many months?
My lord, till 19 September 2025. My lord.
For 1 month.
Yes, my lord, simple imprisonment.
Yes. So today we are on 3rd. Only 16 days left.
My lord, but my lord.
If you violate the order of injunction, you have to suffer for that.
Not kindly, my lord. Only 16 days left. That's why I'm praying for release the petitioner, my lord. Just 16 days left, my lord.
That is why it cannot be stayed without hearing the other side. That's the problem. That is the problem. This application under Article 227
Lordship, I beg to appear for the petitioner.
Yes.
I have filed this petition against civil revisional application before the learned district judge at Alipur.
Civil revision against
Civil revisional application.
why? What was the order impugned in the civil revision application?
Actually, what is happened, my lord? The opposite party plaintiff has filed a suit against me for eviction suit. The suit has been decreed. Then title execution has filed. No copy have been served upon me. Then policial petition has filed in title execution application. And the copy have been served upon me for the first time, that is 23rd July 2022. And upon inspection from the case record, I came to know that title suit has filed, decreed, title execution have filed. And then I have filed an application under Order 9 Rule 13 of CPC along with Section 5 of Limitation Act, which Section 5 application was heard and allowed by learned 3rd Civil Judge Junior Division, and challenging such order, one civil revisional application filed by the opposite party, and that was allowed. And against such civil revisional application, against such order, I have filed the civil revisional application. Kindly Lordship,
So this is Section 5 in connection with Order 9 Rule 13 allowed.
Yes, Lordship.
Against that, you have filed an application before the civil revision. You have filed a civil revision before the district court.
I have not filed. The opposite party has filed.
Yes, and what happened there? Stay order has been passed.
Stay order has been passed and stayed all further proceeding in connection with Order 9 Rule 13 application. Kindly Lordship takes page number 45. That is the order allowing Section 5 application. Paragraph number 6. It came to their knowledge on 3rd August 2022.
Because if the stay is not granted, the civil revision application will become infructuous.
Yes, Lordship.
So, rightly granted stay. If the civil revision application Section 5, they have challenged that order allowing Section 5.
No,
So,
no. I have filed Section 5 application. I am petitioner and
you have filed Section Order 9 Rule 13 with Section 5.
yes,
Section 5 was allowed.
yes,
They have challenged the civil under Section 115 capital A before the district court, challenging the order allowing Section 5.
yes.
So in that, unless the further proceedings is stayed, if that is disposed of, what will be decided in the civil revision application?
So my prayer is, Lordship, stay
I can
that.
do one thing, I can only direct the civil revision application to be disposed of expeditiously.
No, Lordship. Civil revisional application order is required to be stayed.
Why?
So the title execution.
Then the civil division will become infructuous. This case is allowed to proceed. I am expediting the civil division application. This application under
Lordship, I beg to appear on behalf of the petitioner. is an application praying for expeditious disposal of one title suit relating to partition injunction, being title suit number 366 of 2024, pending before the learned second civil judge senior division at Baruipur. Lordship, an amendment application has also been made on behalf of the plaintiffs, the next date being 26th of November 2025.
Who are the learned advocates appearing before the Baruipur court? Have you ascertained?
Lordship, it's Advocate Ajit Krishna Bishas. Plaintiff, Your Lordship, I've got the information of the last order.
And for the opposite defendant?
Lordship, I'm not sure about that, Lordship.
Please inquire. I'm passing it over. Come at 4:15. Who are the learned advocates? Please inquire. Come at 4:15.
But I'm for the petitioner. The petitioner is the plaintiff. It's an ejectment suit by the petitioners who are the plaintiffs in that ejectment suit, my lord. The ejectment suit has been filed on two grounds, mainly on the addition and alteration by the delinquent tenant.
What is the impugned order?
My lord, the impugned order is for the amendment which has to be carried on, and it has been rejected.
We are for amendment rejected?
Yes.
What was the amendment sought for?
My lord, the amendment was sought for only with regard to the postal receipt, which the petitioner, the PW1, himself adduced in the examination in chief before the court.
Give me a minute.
Yes. My lord, only thing which the London trial court asserted that due diligence has not been complied. That's it. And my lord, only thing which we wanted to amend with regard to.
Give me a minute. Show me your application for amendment.
My lord. My lord, at page 171. Second volume.
Why have we annexed so many documents in the civil?
My lord, because this was required to
only
be
an amendment of the
my lord,
plain.
two things have happened. The court has deliberately forgotten the procedure. 7-2 order was done. No compliance to 7-2.
Those are not the issues in the civil division application.
My lord. My lord, at page 173, the schedule of the amendment. And my lord, at page 118.
The petitioner filed an application for amendment of Yes. Yes.
But I have instruction will have to appear in this matter. Just blood for your lordship's assistance will have. আচ্ছা তুমি কোন অর্ডারটি চ্যালেঞ্জ করছো না? 11 July?
Yes.
But the same order is being challenged by me, my lord, earlier.
Occupation charges.
Occupation charges. Your lordship.
Occupation charges.
By this order, your lordship admitted the revisional application of mine. Because I, my lord, challenges this order since it has not been granted with regard to the areas.
Very well, my lord. But I say my point before your lordship today is that
Who are you?
the tenant.
License.
You are the
Tenant.
So you are the appellant in that levy. That's the.
There is no appeal, my lord. It is a title suit going.
My lord, it's,
Sir.
yes,
Oh,
one
there is a
during the
title suit
pendency
going.
of the suit.
Yes.
that point cropped
That is
up, but
only-
I have cited
Only
the
before the
judgment
honorable
your lordship.
division bench. My lord, my very small submission before your lordship today is that in the order impugned, my lord, the order of the judgment of the Connaught projects, my lord, have been, my lord, quoted. Lordship will see that I have got the honorable division bench to show that Connaught projects has been declared to be not.
But my lord is not aware with regard to the subsequent judgment of the honorable.
Be that as it may. My
I'm
lord,
not-
I just say I did not. No. I'm just talking about, my lord, the judgment or the order which is not impugned before your lordship. Kindly sees that it is a judgment which is on the basis of Connaught. That's what I'm saying.
What is your status in the suit property?
My lord, I am, my lord, the tenant because I tell your lordship that.
Where is your written statement?
Yes. My lord, my written statement, your lordship will find at page number 25. It is a written statement as well as, my lord, the counter claim that I make.
Counter claim.
Yes. And if I just request your lordship to see, my lord, internal page number 8 onwards.
Admission.
Premises tenant. And Mr. Mukherjee, your claim is that for license.
License, and he admitted that he was inducted as 5,000.
In a case of this nature, whether occupation charges.
Yes, my lord, I have argued again, my lord, I am ready to argue before your lordship on the
And he
same
says-
exact facts of the
My
case.
lord, by the
Now-
legal notice, my lord, he says, my lord, me to be a tenant, not the license. That is kind of specific case of
What
my.
is your claim? Here,
Or I say
we are
that I am a
challenged by
premises.
refusal to. No, this is in another matter.
No, same
order.
impugned order, same impugned order.
No,
My lord, kindly sees the impugned order.
oh,
once.
your claim was for area of
Yeah,
occupation.
yes.
Oh.
Because paragraph 21 of the written statement, come counter claim.
And according to Mr. I, you say that no occupation charges could have been
My lord, my prayer before your lordship is that.
directed to be paid.
Yes, one of the grounds, my lord, that I have been agitating, my lord, lordship has seen, my lord, 11th of July. 11th of July is the order which is impugned before my lord.
So an interesting point has cropped up. Suit has to be stayed then. I think.
This has nothing to do with regard to the further proceeding of the suit. That's why I have
Mr.
not.
Mukherjee, you will lose your right to get occupation.
No, my lord, I will not. Ultimately, the court will decide in whatsoever way. But during the interagnum, my lord, your lordship cannot.
Let this point be decided.
My lord,
Mr. Mukherjee.
for the adjudication of this point, my lord, the landlord or my lord, the plaintiff cannot be, my lord.
Interesting point you have raised. So let it be decided. Suit. You will be losing the occupation charges pending the suit.
I will not lose.
The
my lord.
suit is decided in the meantime.
The person himself has claimed induction is admitted, 5,000 is the rate. If that be so, my lord, I am not asking anything. At least
there be an interim protection to me, my lord, that I should not be, my lord, making this payment at least. Let the suit, my lord, go. I am not saying this anything.
You deposit that amount, you will get back.
Lordship will kindly appreciate that they cannot do this unless and until, my lord, they say me
You are residing. You are residing. You are occupying. You are not the owner.
In that event, my lord, that will be again.
Are you the owner?
I'm not the owner.
So you are residing?
Yes.
So your case is that of tenancy?
Yes.
Yes. What is the monthly rent according to you?
I said that 4,500 at last.
4,500 at last.
Paragraph 20.
So here
Previously-
5,000 5,000 has been directed to be
No, my lord, his case is of
No, I
5,000.
tell you,
Paragraph
Lordship,
20.
what happens?
Oh, your case is of 5,000.
Tell you,
Paragraph
Paragraph 20.
there was previously 5,000.
Mr. Rai,
And
if
when
your-
my
your
husband
ca-
passed, it was
maybe-
4,500.
maybe your case is of 5,000 occupational charges, you deposit.
In that event, my lord,
Deposit it in court because Mr. Rai, you have to pay. Your case is that of tenancy. You cannot shy away from paying the rent.
absolutely, my lord.
So you deposit the rent.
There is a subject to correction, my lord. There is a procedure for
You are a tenant under whom?
the opposite party here before your lord.
Then you have no difficulty in paying to them.
But in that event, my lord, this order, my lord, stays, but runs. This order which I have challenged before your lordship.
Without prejudice.
My lord, because
Without prejudice, you pay. If you are declared to be a tenant, you will not be a defaulter.
Or projects has gone from 2024. The
differential amount
Now,
will be a
the problem is this, my lord, the basis on which this impugned order is passed, my lord, the basis is
Sir, you are a tenant.
I
You
do.
cannot stay in a
Yes.
property without paying.
My lord, my lord, that is in every other, my lord, tenancy proceeding which what is done, my lord, after the
If a eviction Mr. Rai, if a eviction proceedings under the West Bengal Premises
Yes,
Tenancy Act
I
is
cannot.
filed, you have to deposit to get protection. After all, you are a tenant, not an owner of the property. You have not claimed to be the owner
I
of the
did not,
property.
no.
So you cannot stay without paying anything. So you pay this amount without prejudice.
my lord, before whom, my lord?
You are saying tenancy under him, you pay it to him.
So, my lord, in that event, my lord, this is once again, my lord, going by
You
this
cannot
entire
Mr.
procedure
Rai,
of this.
You cannot say no because you are a tenant.
But I am not saying no, my lord. What I was just trying to impress upon your lordship that I will be doing it.
Mr. Rai, if his suit fails and you win in your suit or your counterclaim, whatever it might be,
Then also
so you will be declared to be a tenant. Then
But I
you
have to do that.
Then you will file a suit for eviction.
Well, in that event, my lord, it
Then
will be
you
the
can
rule
take
that
this that I have deposited. I am not a defaulter.
But in that event, my lord, that would be the rule that in every kind of tenancy proceeding, my lord, this may be applicable for this.
Tenancy proceeding.
But
You
this
can
may
do
be
one thing,
applicable for
Mr.
this.
Rai. I will decide this.
Only I just request
Uh,
you kindly see
If you have any
one
if you
paragraph
have
or one
reservations with regard to paying him, deposit. You cannot stay without paying.
Well, I just in that event,
The
your
Honorable
lordship
Supreme Court in that decision
Right.
directed the amount to be
2024,
deposited
yes.
before the registry
I'll do
of
that.
the Honorable
I'll do
Supreme
that.
Court.
If
I can direct
it
you to
falls from your
deposit.
lordship, I'll do that.
Ashwin.
I'll do that. Man. Till at least, my lord, it is, my lord, decided.
Yes.
Till it is decided, my lord, before you.
After all, if you succeed, you have to pay.
Yes, my lord, I do.
So
Yes.
that will not help you. So after all, you cannot be held. You cannot say that you are a defaulter. I've saved you from that. You cannot say that you are a defaulter. Otherwise, you will alone say, yes, you are a defaulter. You have been saved from that.
As your lordship, grateful.
Item number 40.
আচ্ছা ওই ডিপোজিট হবে না?
Your lordship tagged it. But otherwise, you can say, my lord, I will not.
Mr. Mukherjee, respective parties are the same and challenge is the same order. Please apply your mind. Your mind is somewhere else.
Lordship, item number 40, I beg to appear on behalf of the petitioner, your lordship. In this application, your lordship, I have challenged one order passed by the District Consumer Forum at Barashat, order dated 3rd of June. Your lordship, what had happened was the opposite party number 2 had filed one complaint case being 36 of 2015 and an order was passed on 28th of October 2015. Lordship, at that point of time, the copies and the order was not served upon us, because of which we were unaware of the proceeding. Thereafter, your lordship, the OP files an application under Order 21, Rule 38, that is an execution application, being number 369 of 2015. Lordship, a warrant of arrest and execution has been issued in 2025, 1st of July. Lordship, nothing was, the petitioner was not acquainted with any of the facts because nothing was served. Lordship, we are ready to prefer an appeal before the state forum, your lordship, but for that, we need the certified copy. Your lordship, I have received instruction that, your lordship, at the present moment, there is no registrar, your lordship, at the district forum, your lordship, because of which we are not being able to file the appeal in the meantime. Lordship, we are only praying for some interim protection, your lordship, before.
Why?
So that we
If
can
the
file the
registrar
appeal.
is not there, you cannot file.
Lordship, we cannot obtain a certified copy. Without the certified copy, we cannot file the appeal before the state forum, your lordship. In order to file the appeal or for the stay application before the state forum.
Show me that you have applied for the certified copy.
Lordship, I don't have the copy. Lordship, they do not provide any such hard copy, your lordship. They do not provide any hard copy on
I
the.
have stated whenever you applied, I will direct the state commission to supply you the certified copy by Tuesday. Show me. Show me your pleading that you have applied for the certified copy.
Lordship, kindly grant me a day.
I'm giving you liberty to approach the state commission for obtaining the certified copy. Please approach. I'm keeping it in the next week.
Lordship. The district forum, your lordship. The certificate.
Yes, district
Lordship.
forum. Yes.
Lordship, kindly grant me the liberty.
The learned advocate
41, my lord, I am for the petitioner.
Yes.
This is a suit for my lord eviction entirely on the ground of default and reasonable requirement. My lord, suit is of 2009. My lord, 72 was disposed of, directing the defendant, my lord, to deposit my lord more than my lord 5 lakhs rupees or not. Challenging that they came up before this honorable court. Your lordship was kindly have a look at page 19.
19.
Yes. Your lordship was pleased to not to interfere with the said impugned order, but liberty was given to the defendant that the defendant petition is directed to deposit the area then for the period from November 1999 to January 2024 at the rate of rupees 1400 per month, together with statutory interest at the rate of 10% per annum within 1 month. From that order has not been complied with. I took out an application under section 7.3. That is pending for consideration. I am only seeking a direction about the learned court below to dispose of the said application within a time frame.
When did you file 7.3?
But I filed my lord on August 2023.
August 2023.
2023 after passing of my lord order of 7.2.
It is fixed on 24th of September 2025.
My lord?
It is fixed on 24th of September 2025.
Next
written objection filed.
No written objection has been filed. They took out an application under section 151 for the installment before the learned court below after passing of your lordship.
Yes.
My lord, the defendant is the petitioner before your lordship. My suit for eviction, my lord, entirely on the ground of default and reasonable requirement. My lord, no summon has been served upon me either through my lord, post office or my lord, through my lord, serving officer of the court. My lord, on 17th April 2025, my lord, I took out 4 applications, one for vacating ex-parte hearing of the suit, another for show cause, and another for supplying copy of the plaint, and my lord, 72 application. If you also kindly turns to my lord.
Who are you?
I'm for the defendant number 4.
Defendant number 4.
4.
Who are defendant numbers 1 to 3?
Defendant number
Who are defendant numbers 1 to 3?
defendant number 3 is my father. Defendant number 2 and 3 my brother.
3 is your father, 1 and 2 is your brother.
Brother.
What did
My mother was the tenant, original tenant in respect of the suit property. And my lord, after the death of my mother, my lord, suit has been filed against the legal heirs of my mother, treating them as a tenant in respect of the suit property. And my lord, I have challenged the relationship of landlord and tenant between the parties because, my lord, this is a, my lord, entire property, my lord, consists of 31 cutters of land. He purchased, my lord, 2 cutters of land. Now, my lord, I am not a tenant under him. And he filed the instant suit. And my lord, kindly turn to my lord, order dated 17th April 2025. And 15 May 2000.
What happened on 30th of August 2024?
Yes. That is the main order, Lordship.
What happened on 30th of August 2024?
Lordship, the main issue is that.
Sir, please.
Okay. My lord, prior to that, my lord, I am coming, my lord. My lord, kindly have a look at my lord order dated.
No, I am asking you what happened on 30th of August.
30th August of 2024, my lord. The defendant number appeared.
Defendant number, then who appeared?
Number 1. Defendant number 1. Defendant number 1 appeared. And my lord, 7-2 was not maintainable. Holding that, my lord, and defense has been struck out of defendant number 1.
Not challenged.
Challenged. I have challenged this order.
30th of August 2024.
Yes.
You are who?
I am defendant number 3. After passing of that order, my father died.
No. Here is the challenge by the defendant number 4.
Yes.
So that order was rejection of 7-2 of the defendant number 1. How could you challenge that order, sir?
Well, after the passing of
4 written statements filed. Defendant number 1 written statement, 2 another written statement.
No. Defendant number 1, my lord, appeared. Filed 7-2 written statement.
Rejected.
After that, passing of.
After 2 comes. Defendant number 2 comes, filed 7-2, rejected, then 4 comes.
No. After that, my lord, my father died.
When you will vacate, Mr. Haldar?
No, my lord, kindly have a look at my lord. The order dated 17th April 2025. My lord, on that particular date.
Prior to going to 25, I am at 24. I cannot cross 24 to come to 25.
There is no good relation between the brother and the sister. Can you have a look at my lord?
No, there is no good relation between the brothers at the time of filing the suit. Execution, there will be good relation. All of you will come to oppose the execution then.
After vacating the ex-parte hearing against the defendant number 4, without giving opportunity to file.
Show me your application under section 7.2.
Kindly have a look at page 20. Kindly have a look at page 20.
Yes. Page 20, no pagination is there, Mr. Haldar.
Kindly have a look at order dated 15th May 2025.
Order dated?
15th May 2025.
Yes.
Today is fixed for hearing the so-called petition along with ex-parte vacating petition, filing written objection by the plaintiffs. Learned advocate for the plaintiffs has filed Hajira. Learned advocate for the defendant number 4 has filed Hajira and moved the so-called petition along with ex-parte vacating petition filed on 17th April 2025. Heard both sides consider. Upon perusal of the record, as well as the petition filed by the defendant number 4, it appears that the ground mentioned in the said petition is found to be sufficient, and as such, the petition is hereby allowed. Accordingly, the ex-parte order passed on 17 August 2022 is hereby vacated with cost of ₹5,500 to be paid by the defendant number 4 to the plaintiff. Further, it appears on the AD card that the defendant summons have been duly served upon the defendant number 2 and 3, but in spite of that, they did not bother to appear before the court till date. As such, the suit is fixed for ex-parte against them to such and such disposed of on 3rd July 2025 for framing of issue and payment of cost. So, by this order, my lord, the order of ex-parte hearing, upon seeing the, my lord, the service of summons, because nothing has been served upon us, either through postal peon or, my lord, the serving officer. After the my lord, order of expert hearing has been vacated.
Mr. Haldar, what is your status? Are you a joint tenant or a tenant in common?
My lord, the plaintiff my lord filed the instance suit.
I'm asking you. Forget about the plaintiff. What is your status according to you? Are you a tenant in common or a joint tenant?
Since my lord, I have inherited the tenancy right from my mother, my lord, I is a tenant in common.
So you can file independent application 7-2
My lord, kindly have
or 7-2 against one rejection binding upon the others.
my lord, if you want, my lord, my application, my lord, having been, my lord, my application having been, my lord, allowed, my lord, vacating the expertise hearing of the suit against me.
Maybe you can contest the suit, but you cannot file 7-2 independently. You contest the suit, nobody is stopping you.
My lord, there is no, my lord, good relation because, my lord, kindly have a look at my application, my lord.
Maybe,
Kindly have
but
a
you
look
are
at
a
my-
tenant in common.
My lord, they are
You
not,
are a tenant in common. You cannot have independent rights.
my lord, so far the relationship,
You are all of you is representing them. If one of the heirs he suffers something, it's everything falling from that estate. Cannot be bifurcated, cannot be divided.
my lord, if there is a, my lord,
Show me that you have made out that case in 7-2.
my lord.
Your relation between these dependent number 1 and 2. Show me that.
So kindly have a look at page 17.
Yes. There is no pagination, Mr. Haldar.
I'm sorry, my lord.
Yes. How long it will take?
My lord, kindly have a look at page 17, application under section 7.2.
7-2, yes.
That there is no relationship of landlord and tenant in between the plaintiff and the
Your
defendant.
cases of joint tenants. Paragraph 3. How can you say so? It's contrary to your statement.
No, I have to go by the record.
What record?
This record.
Yes. But if you are a tenant in common, you are inheriting from your mother, and when your mother died,
Mother died.
prior to 2001, after 2001, when?
After 2000. Anyhow, my lord,
I'm asking you.
my lord,
Prior to, please.
my lord, he has, after the death of my mother, he has treated us,
Please tell me the date, sir.
he has treated as a tenant in respect of the suit
Please.
property and filed a suit for eviction.
Please tell me the date. Prior to 2001 or after 2001?
I have to ascertain, my lord, because
Has
according
to be after 2001. Has to be after 2001. So mother was the original tenant. So after 2001, gone.
No, my lord, after, if my lord, the,
Consistency একটা দিন তো 5 years.
no, that's true, my lord. But the here in the instant case, my lord, the plaintiff has accepted all the legal heirs as a tenant. All the legal heirs as a tenant. It is not his case that, my lord, I have no right. After expiry of 5 years, he has accepted us as a joint tenant. That is his
Show me
case.
the averment in the plaint that you are the joint tenant. Show me. Yes, how long it will take? Senior lawyers are waiting.
It will take more than 15 minutes. At least 15 minutes.
15 minutes.
10 minutes now.
Let us come next day. Let us come next day.
You will come next day.
But Mr. Basu Malad was to reply on Malad those MSME judgments Malad which are shown.
Please paginate the.
And in the meantime, I will take up my matter.
Yes.
Mr. Halda, please paginate.
After 4:30, my lord, kindly don't detain me.
Mr. Basu will take more than 10.
Reply cannot extend more than 10 minutes. Dakun. Fixed matter. Reply in a civil division application cannot extend more than 10
I know that. But if for any reason it is extended, my lord, kindly give another date.
For any other purpose, Mr. Basu?
No.
You are saying matters are not being taken up, matters are not being heard. So move
Rule
the
of the
matters.
day. Matters are not being taken on the rule of the day. Now it.
That is why I am taking up. Please move.
Taken up for up to 4:30. For that.
He is very senior and respected. I'm sure 10 মিনিটে শেষ করেছে তাই বলছি।
ওদের গ্যাস দিতে হবে না কি বলছো বল
10 মিনিটে শেষ করে দাও তাই।
দেবো
আর কিছু বলছি।
সময় গ্যাস point was whether an award or any order passed by an authority who has no jurisdiction to pass an order.
Nullity.
Is it nullity? I have shown certificate. Which cannot, my lord, stand in the same footing of an order illegal having jurisdiction by the court. It cannot be equated. One of the judgments cited by Mr. Banerjee, that is yes, 2025 5 Supreme Court cases.
2020
case
2025
2025 5 S 780.
2025 5. Yes.
So he is heavily relying on this judge. What is the case here, my lord? Kindly come to here is the case where the authority passed an order holding that the claim is barred by limitation. That has been challenged before the 227 procedure. Not only that, my lord, while holding that the petition is not maintainable, the court gone into saying that whether it is barred by limitation or not. That is at paragraph 5. So this is an error, according to my humble submission, here in this case, which is an error within the jurisdiction, which cannot be equated in a case where the court has no jurisdiction at all. So this judgment, my lord, can be distinguished on facts, on the proposition that an error within jurisdiction and no jurisdiction. So far we are concerned, we have no jurisdiction.
According to you, there was no jurisdiction, so
Because of the fact, Silpi construction still holding the field, although our subsequent judgment is said a larger base to be considered, but it cannot be diluted till such time the order is not set aside or third opinion has been not given by the Supreme Court. That judgment still hold the field. It says unless it is registered, normal logic. This is special statute, special privilege given to a person who is having MSA. Privileges I have shown to your lordship while I argue the main matter, what privileges they are having. So here, to get that facility, he has to be a registered, and that registration has to be strictly constituted, because he is departing from general law. Here, admittedly, when the agreement was entered into by myself and Mr. Banerjee's client, it was not registered under that category. Admittedly, it was registered after that category. But it can be, my lord, had it been in my knowledge that there are so many interest parties, cumulative effect. If I have failed to pay, then I could not have entered into an agreement. That this is civil law will not be affected if I am default. The special law will inflict an huge amount of interest and penalty I have to pay here. I may not have entered into it. So according to my humble submission, my lord, if you are getting a privilege, special privilege, the horse as normal course of law, then your registration is highly required on to get that advantage. Till such time you are not getting the advantage, cannot claim to be a MSME. Have this privilege. So now, my lord, kindly see the another judgment, that is
which citation?
Yes, sir, my lord. Citation called
NBCC.
NBCC. Let me show you the NBCC.
তুমি দেখাচ্ছ
আমি দেখিয়েছিল
তুমি সুপ্রিম কোর্টে গিয়ে তুমি এলাহাবাদ হাইকোর্টে
না আমি দেখিয়েছিল ওটা না মানে কাইন্ডলি কাম টু এমবিসি
The difficulty is because of this time gap between two hearings.
one sitting is easier for the court also. Here, my lord, the Supreme
I
Court
could have, because, but due to the pressure of motions, could not have kept it.
which may say anything because we are not there. We may say anything because this is I am not there. He knows what he is sitting, what the Swiss is pinching.
No, that is why I cannot keep these matters at an earlier point of time. That's the difficulty because
I don't understand. The council practicing a
it's creating a
I understand this.
it's creating a problem because this
Time gap intervene so many matters. Some matters may be very important, not in casual manners. That is filing your lordship's mind.
and these 4 p.m. matters are all contested, heavily contested matters.
So
That's the difficulty.
in my lord, this judgment is
Please, both of you, I will request both of you to give a short notes. Because
our solution
We'll
is
do
very,
that.
very short.
please give a short notes on those points
NBCC,
and give those distinguishing points of those judgments also. Both of you.
I have just now said this one judgment he has mainly
Yes.
cited.
No, I
say that
Tamil Nadu
227 is not maintainable. That is the
That's
main
right.
point. So that,
227 not maintainable, you have to go to section 34.
yes, that I'm saying. To that my
Sorry,
initially I'm-
so sorry. Just accept it. 227 not maintainable.
Behind Mr. Basu, court is in your front,
Yes.
not behind.
And Malad, another
I have to see the behind.
another point, Malad, with regard to Malad, that registration also I've shown, Malad, that has to be Malad, the last judgment which Malad explains Shilpi and says Malad has to be before Malad it is referred. That also I've shown.
That is not the judgment. That is
Yes,
referring
sir.
judgment. Nothing decided in that. NBCC, nothing decided.
Not sure
Makes an
decided.
opinion holding that earlier not at par with Shilpi, so it is referred. Well, kindly see this. Kindly see, my lord, this judgment.
No, Mr. Basu, there is one distinction. You are right. It's referring. It has been referred to a larger bench, but conclusion is there. Conclusion after considering an earlier decision may be of a same strength, Mr. Basu. If let us assume both decisions are of same quorum. Subsequent decision considers the earlier decision and makes certain observations. But since
not finding.
But since both are of equal quorum, the later bench or the subsequent bench thought it fit to refer it to a larger bench. But some conclusions are there.
Those are not conclusion. This is my humble submission. Kindly, the judicial decorum say, had it been concluded there, you stop there. Why should refer? That for ABCD reason, we disagree with the finding of such and such, and this is our conclusion. NBCC has not concluded. Had it been concluded, should not have been referred.
Now the difficulty is paragraph 56 of NBCC. Please consider paragraph 56.
Yes.
The entire observations of the Honorable Supreme Court on this. 56.
56, NBCC.
Maybe some you are looking at some other version. Paragraph may not be telling. It's the conclusions and reference to the larger bench under that heading.
Yes. Concluded refers to the larger bench.
Yes, the paragraph after that. Yes.
On the interpretation of the provisions of the Act, we have arrived at a clear opinion. Opinion.
Yes.
And have expressed the same. Right.
Next.
Though it is possible for us to follow the precedents referred to in para 27 to arrive at the conclusion The judgment in the case of civil persons and such and such, such and such, and such and such cannot be considered to be binding precedents. On the issue that has been arisen for our consideration, taking into account the compelling need to ensure clarity and certainty about the applicable precedents on the subject, we deem it appropriate to refer this appeal to a third larger bench.
Now, Mr. Basu, there are two conflicting decisions then. There are two conflicting decisions. It does not merely say that I am referring. There are two things.
Can you visualize your lordship as this side or that side, when I seen there are two conflicting judgments of our court. If there is no reference, a court can say this is the subsequent judgment having same strength, I will follow that with giving reason. Need not be necessary to send it for larger bench. The moment, the moment court thinks that it is required a reference to a larger bench, meaning thereby the subsequent bench is not clear of his view. That's why I'm sending it for reference. Had it been, there is no power. If your lordship found one judgment is on reasoning is much better than the earlier one, having same stage.
So here, yes, that there lies a distinction. There are two things. One is, let us hypothetically consider there are two division bench judgments, conflicting views. Now those are placed before the single bench. Bench of a lesser forum. So now both are binding.
Yes.
Both are binding. The single bench cannot say I am referring it. That's the difference. Or both are binding.
What can say, according to my reading of both the judgments, these are all reason, but as a single judge, I cannot do this. Let it refer to a larger.
If can accept either of the views also.
That is not acceptance, I am saying. What I am submitting, my lord, can you test my submission? That is not the acceptance. On the giving of the reasons of the particular division bench, I am of the opinion that is on more logical view. But to lead the judicial discipline, I am referring to a larger bench. That is not the binding. That is not the binding precedent of the single judge. That's why he is referring. Can I test my submission? He is not saying this is binding. This is logically correct, according to me, out of the two. But I cannot do anything. It has to be referred. If it is referring, my lord, is diluting is conclusion. Can you see the language?
I could have concluded, but I am not concluded.
I could have concluded, so it has not been concluded.
I could have concluded, but I am not concluded.
Yes, because both are of equal strength of quorum. That is why, in order to maintain the judicial propriety.
Yes. So, till such time this is finally decided, this judgment, the subsequent judgment of NPCC, is not a binding precedent. Binding precedent is silpy. I give an instance, I repeat, pardon me for repeating. I will be.
We're being distracted
by my brothers outside. That after 4:30 you are arguing. My lord is a single judge, having two divisions. What my lord will do? My lord has to follow one. But your lordship cannot do anything because of the judicial discipline.
So there is also a decision, Mr. Basu, which says, out of the two, one can be followed better in point of law.
That is not the binding effect, I am saying so. This is the opinion of the judge.
No, both are binding. Both are binding upon the single judge.
But a single bench is considered both are binding.
Both are binding.
But the single bench can say that logically this judgment is more logical. But I cannot accept that because I am a single judge. I cannot accept one of these out of those two binding. I can refer it. Or he can also, my lord, there are judgments very simply also can say this is more logical in accepting this.
Yes, yes. That is
done. If it is not done, then I should refer. The moment he is referring, this binding effect of the judgment lost its force. Then the previous judgment, who is saying that this is the conflict, those judgment will bind the parties till the larger bench will decide that. This is my suggestion.
You have an authority for this.
The authority is the logic.
There are authorities on this, Mr. Basu.
I will check in my written submission only one judgment. If I get,
I think in I am forgetting the costatal. There this same point arose.
Remembered वाला tele supply audio loss
Some dental association or medical something with regard to
I will
that.
check up nowadays juniors are equipped with those
With
things.
regard to this, what is the effect if it is referred to?
This is automatically the law is nothing but logic.
I give a relied on a judgment, my lord, which said that, my lord, whatever, even if it's referred to, my lord, whatever was prevailing would be, my lord, the law. I've given that, my lord, order.
No, that is Mr. Basu says.
That's Tamil Nadu. Tamil Nadu decides, my lord, what the law is, and then, my lord, says that it should be placed.
Yes, I think that is the judgment of Justice Bose you have referred.
Yes, yes, my lord. Absolutely.
2023 live law SC.
Absolutely.
If it is hold, but the logic is clear. If it is hold by a judge or a bench, it need not refer. Referring will be on the ground that it is not yet decided.
I could have concluded, but I'm not.
My lord, Tamil Nadu, my lord, is a bench of, my lord, 3 judges.
Tamil Nadu.
That's the judgment. I'm the Supreme Court.
That's all.
Tamil Nadu. Yes.
Sorry, not Tamil Nadu. Tamil Nadu was another judgment which I cited. No,
Yes. No, this referring, the effect of this reference is in Rajneesh Kumar Rai.
Yes, my lord, Rajneesh Kumar Rai. Correct. Rajneesh Kumar Rai. 2023 14 SCC 782. I've
So
given a
that's,
copy.
what is the reference? Because you have given me live law.
Yes, yes, one of that. 2023.
live law SC.
No, 2023 14 Supreme Court cases 782.
2023 14 SCC.
782. 14. Volume 14 SCC 782.
Yes.
My submission will be if it is bench is holding it, not the necessity of referring.
No, no, it's Tamil Nadu. And
yes.
Round. We'll put it in.
My submission is this, that if the court is holding it, in spite of the judgment, relying on the judgment, no, this is not a good law. Our law is a well-reasoned judge. So not necessary to refer.
So according to you, Shilpi is binding. Till
Larger bench say something contrary to this. Suppose today, now it is referred. Now, my lord, on the basis of this subsequent judgment, your lordships, my contention is negative. Tomorrow, reference court say otherwise. Where I am?
that is for you to advise your client what you will do.
India Glycol says 227 is not maintainable.
That is for you, Mr. Basu, to advise your client what is to be done.
That's the reason. That is the reason.
I have to decide as on this date what will happen after that.
That's why
I can.
You
give
take
the-
his,
I am well aware. That's why I say that judgment today has no application because it has been referred. The referring judgment has no application. The judgment which was said to be not in accordance with law thought by the subsequent bench will apply till reference is answered.
and also unless, even if it is pending before the larger bench, court can accept one of the views. Mr. Chatterjee is there, he has argued in one matter.
That cannot.
Well, India
Like
Glycol.
after division bench judgment, it is.
Well, India Glycol also says it's not maintainable. Article 227 is not maintainable. Well, that there is a subsequent judgment which refers.
Anything more, Mr. Basu?
Not maintainable on the ground and an error within jurisdiction.
Anything more?
No, nothing.
When?
Oh, that's me.
Well,
When
we'll
can you file this?
Give me 1 week time.
Well, my advice would have been section 34 and comply with section 19 and deposit.
That I have given a difference. Today, my lord, I have been appointed by my client as an arbitrator, past an award. And
We'll give it
Mr.
next.
Banerjee's client came to challenge that.
That's the law. It's law says.
Then I will do it. What award?
Law says. Section 19 says.
Even if not appointed, even I will pass an award.
When, Mr. Basu, when?
Give me 1 week time.
One.
Next week.
Today we are third, 11th, 12th, when? Mr. Banerjee?
11, 12, my lord, whichever, whatever. Will. Huh? We can name it knee, but then no, should do notes file.
I have hesitated to
What?
for 17.
17?
That's why I'm hesitating. আমি তো করতে চাইছি না।
Whatever little is retained here, that will also.
I know that.
12th take over. Well, we can give it 12th or more 5th, whatever.
17th will be
15th take over.
12.
12th.
Yes.
12th or 15th, you will be getting a weekend.
15th. Very well, 15th.
Mr. Basu Lanet. Don't make it voluminous than this revision application. Don't make it 2 or 3 volumes.
But the judgment copies should be again give or it's not required.
It is not that case. It is the only question of law.
Yes. Why so crowded? 4:45.
After 4:30, I am arguing. That's why everybody comes here.
There's one very urgent matter.
Item number 4.
This similar, it's a 3 p.m. matter. 3 p.m. matter, my lord, it's been there for, my lord,
3 p.m. matter. Now it's 4:45. What were we doing in 3 p.m.? It was called on. Which item? So Mitra is there. You,
309.
what is the urgency, Mr. Chatterjee?
Because the bank has now said that I should remove whatever is there inside the moves, inside the flat, so that, you know, they can give possession completely, you know, to the other side. And if the date has been fixed on the 6th.
Mr. Chatterjee, only difficulty is that you are mentioning for upgradation fixed from the monthly list.
Your Lordship
You are
has fixed it. Your Lordship has fixed it on the at 3
I
p.m.
fixed it, but if I am allowed to proceed serially, I can reach that. That's the difficulty.
There are just
That is the
4 matters for 3
difficulty.
p.m., my lord. If your Lordship will, any day, my lord, your Lordship pleases. There's
And
just 4
yesterday,
matters.
yesterday also from 2 p.m. I could not sit. That is why some backlog of yesterday's matter.
Absolutely.
I've concluded today's matters, but yesterday's matters.
Completely
that-
understand that, Lord. But
that
this
is the
a
difficulty.
practical difficulty we are facing here. Lord, it's up to your Lordship, Lord. Kindly, any day, Lord, there are just 4 or 5 matters your Lordship has fixed for 3 p.m. Not more than that. Just 4 or 5 matters.
This motions first time
No,
untouched
definitely.
matters.
Motions, my Lord, before the vacation, your Lordship will have
That is the only
We have
difficulty.
filed an application as well in that matter, my lord, because I've been thrown out. Challenging that sale, my lord, it's the main revision.
All right, remind me in the next week, Tuesday or Wednesday. Let me see how far I can.
I shall do.
Yes, Mr. Mitra.
2nd, 4 p.m. my lord.
409.
So kindly, my lord, fix it. I cannot tell your lordship to take it up now.
No, I have fixed it for today, asking you your
No, it
convenience.
was for yesterday.
Oh, yesterday. Can it wait till after the vacations?
Only difficulty, my lord, I told you, lordship. My lord, they don't believe in the principle that survive, live and let live. They don't do that. I could have understood, my lord. I would not have done this, my lord, had they be paying, my lord, even at the, my lord, prevailing rate. They are not
Kalke
doing
ki
that.
ache, kalke.
We have
Oh,
been
tomorrow there is 325. There is a reference. Otherwise, it could have been subject to.
Today, next week, my lord, kindly.
all along we have been tendering the existing rent. All along we have been tendering the existing rent and they have to return us via check.
Now, if you sort it out with Mr. Mitra's client, I have no difficulty. So, but he has to according to him, you are not paying at the current rate. So you are paying at the old rate, not as per the agreement also.
Two increments to
Two increments are there as per the agreement. Even if your contention is accepted that yes, they were not justified in cancelling or whatever it might be, then you are liable to pay as per the current rate. So you are defaulter, you have not paid two increments. That he is justified in saying so. If you can sort it out, in the meantime, you have to pay. If you say that yes, I want as per the agreement, you have to pay according to the agreement. If you have shown some bona fide, you would have considered that. Because after all, he is also answerable to his client. That's the
about 45,000 square feet on VIP road, madam. On VIP.
And this was fixed, I think, in agreement was on 2019. Taking that at that point of time, what would be the rate as well as the escalation? Now we are in 2025.
Because your losses was suggesting the option for regularizing the lease.
No, that I did not.
That so now we are hearing, but provided you have not paid, you have not shown your bona fide. Till that time, some opportunity was given to them. You could have come up showing your bona fide to them. They could have considered that. Now you are saying I am depositing GST there.
No, those are of no value. I can show you.
Next week, how are you placed in after?
I'll adjust my note. Kindly.
কালকে তো রেখে লাভ নেই। তো আগে because I'm trying to take it up because last 2 weeks motions there will be a heavy pressure on.
Can it be at 3:30? Because I'm not very certain, but possibly your lordship would also want to get some intimation,
10th.
Okay. There is a farewell,
Oh.
Possibly it's being organized on 10th. I'm not very certain.
আর একটা কয় বলছেন 16 again
15th would be.
Maybe a difficulty, so
That's for certain.
so তারপরেও কি হবে?
Can it be before 15th?
Before 15th?
For this, or my lord, kindly keep it, my lord, as a parted matter.
Before 15th, Mr. Mitro, there is
Kindly keep it
difficulty
as a parted matter.
that I will consider. Let it be on. Oh.
Because on 16th, possibly there would be some changes.
Part heard subject to
I don't have any.
let it appear on 16th. It is
The parties consent to this. We shall not leave your lordship. That is for certain.
only difficulty is that before vacations I do not know. Yes, that's the and some matters are fixed and motions are also.
I will not take long.
File about. Mr. Mitra.
Sixteenth at 4 p.m.
16th at 4 p.m. Tentatively, I do not know. Huh? Fixed at 4 p.m. Time to ask. Thank you.
Next.